Delivery of order, item number 1.
For reasons mentioned in the order, the prayer for bail of the petitioner is rejected.
Item 2.
For reasons mentioned in the order, the prayer for bail of the petitioner is rejected.
Item 3.
Item 3, Mr. Sharma, I need your assistance in perusing the case diary. I'll deliver it at 2. Some clarifications are required. During lunch, you meet. We'll go through the case diaries. Some clarifications are required. At 2.
Applies your question.
Item 4.
For reasons mentioned in the order, the prayer for bail is rejected.
Item 5.
The prayer for bail of the petitioner is rejected.
Item 6.
The prayer for bail is rejected.
Matter is very urgent. It's criminal. This is a repetition criminal minor. Maybe listed for motion.
Senior court is there.
The punishment up to 7 years.
No, it is only with regard to bail. Criminal petitions, there are 2 other senior courts. You have to mention before senior most.
There is no
That
special act.
that differentiation of special act up to 7 years, less than 7 years is only in respect of bail.
Lordship, I beg for listing a bail petition, Lordship, for tomorrow for withdrawal, Lordship. It's a special act.
Okay. Okay.
May it please, my lord. My lord, as regards to item number 26, my lord, I am appearing on behalf of the informant, my lord. I am praying for a week's time, my lord. Item 26.
26. You have
See the
informed,
applicant.
you have no objection.
No. It's been fixed on 14th.
Heard Mr. M.K. Das, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor, who has informed that the case diary is available. Also heard Mr. A. Chaudhary,
Lordship.
learned counsel for the informant, who seeks some time to file written objection against the prayer for bail made by the petitioner. Prayer is allowed. Let this matter be listed on 13th, 14th of August.
Interim may be.
The interim order shall continue till next day.
My lord, I have a similar prayer as regards to item number 45, my lord. This is IA for modification of bail condition, my lord. It may be also listed in the next week, my lord. Item 45.
45, you have to inform.
We have informed, my lord. Mr. K, we have informed Mr. K. Alba, GST, pending counsel GST.
Okay. On request of learned counsel for the petitioner, Mr. A. Chaudhary, let this matter be listed when?
Next week, my lord.
In the next week on a date to be fixed by registry.
Obliged.
May I please? I need to mention for a listing on bail application, madam. AB, madam, the anticipated special act is there.
When have you filed?
Madam, yeah, on 4th of this month. Can it be on the Friday, madam, at 8, madam? 8 August.
Okay.
Master place. With legal lordship, I beg to mention for listing of an I for correction of an order.
My order
Yes,
passed by me.
yes. On 1st of August.
Okay, when do you want?
While if lordship permits today.
What correction?
Your
Ty-
notes,
Typographical.
typographical, the gist is, gist.
Oh,
piece
okay,
was-
okay, today,
Matsu,
in the second half.
Matsu. I paid for listing upon regular bail application. I filed it on the fourth, Monday. Case is also numbered, but it is not listed.
When do you want?
Tomorrow. Regular bail, only CD will be.
11. 11.
Practice on Friday.
Oh, no, what is the matter? NDPS.
Regular bail.
What is the offense?
Bail is under POCSO Act. Section 4.
Pending trial on 11th.
May I please, Lordship. Lordship, I beg to mention item number 31, Lord. In this case, my Lord, what happened, Lordship, the petitioner have been arrested, and this will be bail.
Heard, Mr. What is your name?
R. Islam.
R. Islam Lamin, counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application, as same has become infructuous. The prayer is allowed. This case is dismissed on withdrawal.
Diploma. May I please? I beg to mention item number 8. Kindly pass the report that we did. I got it.
You have informed the other side,
Yes.
whom you have informed.
Okay. I informed the others. Okay, let me
What is your prayer?
clear it. Okay, next. In this case, T.J. Mohanto sir is yes.
Why are you praying?
Okay.
Why the adjournment is prayed?
The next earlier date first an order that the one affidavit filed by the petitioner.
That has not yet been filed. Okay, what is your name?
M.A. Mondal.
On request, heard Mr. M.A. Mandal and counsel for the petitioner, who prays for an adjournment. He also, he has submitted that he has informed learned counsel for the other side regarding his prayer for adjournment, who has no objection to the same, as the prayer is allowed. Let this matter be listed
Next.
after a week on a date to be fixed by the district.
And it-
In the next week on a date to be fixed by the district.
May I please, Lordship, I beg to mention for listing of regular bill, Lordship.
When have you filed?
Filed, Lordship, 4th of August.
What is the matter?
Step
11th.
As for this list, my lord,
Roster some. Roster.
appropriate bench, my lord,
Which matter?
this is the writ petition criminal where punishment is less than 7 years other than habeas corpus. At the bottom, my lord.
Okay, yes. What is your prayer?
Take the file under Article 226(2) of the Constitution of India or territorial jurisdiction, because complaint case has been filed in the before the learned CJM Calcutta, my lord, whereas the cause of action
No, what is your
taken
prayer?
for quashing of the proceeding. my lord.
Has it been listed? Your prayer is for listing only. So that should be your prayer.
That's what it is.
When do you want?
Because possible, my lord.
Okay, tomorrow let us see.
49, Lordship.
Item number?
49.
Yes, what is your prayer?
6 August, Lordship.
You have informed the petitioner. He has agreed. Heard Miss N. Kakoti, learned counsel for NCB, who prays for an adjournment. She submits that she has informed the learned counsel for the petitioner regarding her prayer for adjournment, who has no objection to the same. Let this matter be listed after 2 weeks on a date to be fixed by registry. No fixed date. On a date to be fixed by registry.
Lordship, I beg to mention item number 15 and 16, Lordship. In both cases, Lordship, the scan copy is received by registry, Lordship. But it is not tagged with the record, that may be bring in record, Lordship. And
How you came to know?
I inquired, Lordship. I have inquired
Find out.
in both items.
Okay.
Matter may be taken up at 2.
No. It will be all in on its turn.
Lordship.
Item 47 for withdrawal.
May I please, Your Lordship? First, I would like to withdraw the matter on instruction of my client.
What is your name? Heard Mr. A.B. Datta, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Bail hearing be item 13. Item number 13.
After something.
Item 14.
May I please, Your Lordship, item 5.
Yes,
My senior is on leave, so matter may be passed over for the time being.
Item 14.
अरे microphone भी लग गया से sound आ रहा है. Yes. Okay, after some time.
Item 15.
Okay, let it come. We'll take it after it comes
16 also.
in the second half.
Yes, sir. 16, item 16 also.
Okay, in the second half, 15, 16.
Item 17.
Sequence through quas and
Did we not proceed?
none appeared for the petitioner on call. Learned Mr. K.K. Parashar, learned counsel for learned additional public prosecutor, prays for some more time for producing the case diary. Prayer is allowed. When?
23rd.
Let this matter be listed on 23rd of 22nd August. Where is the petitioner? You are ready? None has appeared for the petitioner on call. Ms. N. Kakoti, learned counsel for NCB, seeks a week's time for filing the objection against the prayer for bail. The prayer is allowed. Let this, Mr. Datta, she is seeking time for filing objection.
My lord, in fact, my lord, the record has come, my lord, where, my lord, there are 4 accused, my lord. Already one has been granted bail.
Let them file objection. A week's time. NDPS matter. The prayer is allowed. When will you file? 14th.
Right.
Let this matter be listed again on 14th. Show the presence of Mr. N.J. Datta for the petition.
Item 19,
My lord, this is regular bail application, my lord, and petitioner is behind the bar from 2nd March 25, my lord. And in the meantime, my lord, the co-accused has been granted bail by the learned court, trial court, my lord.
I'm sorry for interrupting, Lordship. Office note dated 4/8/25, Lordship. Service report is awaited, Lordship. Steps was taken very recently, Lordship.
This is a POXO case.
Yes.
My lord, one section has been.
Your Honor,
Otherwise, my lord, co-accused has been,
on earlier occasion, Lordship, steps were not taken. So
You
the-
withdraw this and go before the trial court. That
no,
option
my
is
lord,
there.
I cannot-
Otherwise, we will have to issue notice.
Notice have, your lordship has already issued.
On the first occasion, it was issued, but they had not taken step. Thereafter, they took steps very recently, Lordship. Probably in 37, Lordship.
Heard Mr. J.I. Borbhuya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 4/8/2025, it appears that service report in respect of notices issued to respondent number 2 has not been received by the registry. Stop. Learned additional public prosecutor is requested to get information regarding the fate of notice issued to the respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. When?
Can it be on the next week, my lord, 12 or 13, my lord?
13. Let this case be listed again on 13.
item 20,
Lordship, pass over for the time being.
So,
item 21,
the case diary is there. Why? Today, you were directed to produce the case diary.
Answer may be called Lordship.
No, is it a charge sheeted case?
No, Lord. Investigation, they are given opportunity to submit objection.
There is a direction for calling the case diary. You have not gone through the orders.
File our objection, Lordship, or objection received but some difficult, Lordship, we could not file our objection, Lordship.
No, you have not prayed for filing objection. You were directed to produce the case diary. When will you produce?
We have pleaded violation of the constitutional provisions of the mandatory provisions of 47, 48.
Yes, no, but case diary has to be
Yes,
prepared.
Lordship, they have got 2 weeks time, Lordship.
Lordship, majority of Iowa got transferred, Lordship, that's why.
No, that cannot be a valid ground. That somebody is transferred. And at the time of transfer, they do not take case diary with them. You assured this court, when will you produce?
By 22nd August, Lordship.
No, in the next week. Heard Mr. D. Ullah, you suggested it, when can you produce? Also heard Ms. N. Kakoti, learned counsel appearing for the NCB, who submits that the NCB intend to file a written objection. She also prays for some more time for producing the case diary, as case diary could not be procured due to frequent transfer of investigating officers at the NCB office. Considering submissions may suggested date 18.
Right.
Learned counsel for the NCB submits that she would be able to produce the case diary on 18th of August. So considering the submissions made by learned counsel for NCB, let this case be listed on 18th of August for case diary, as well as for written objection by the NCB.
Okay.
Item 22.
Yes,
He didn't,
nobody is there.
he didn't.
We'll take it up after something.
Pending item 20.
May I please, your lordship? 483 application, lordship. And the petitioner is in custody for the last 52 days. FI is at base 10. FI is lodged on 12/1/2025, and the petitioner, he was arrested on 15/6/2025. lordship. No, nothing was recovered from him, lordship.
Yes,
In Helm PS case number 3/25, forwarding it as page 11, XRB. On custodial integration of one Sinjackson Balte, alias Sonpu, his name was implicated, Rahul Amin, the accused petitioner.
from where you are reading? Forwarding report of the,
What is page
no,
11?
what is the accusation?
Is that he's an active member of an interstate poaching gang. Interstate poaching gang have been hunting endangered species, and he is smuggling arms and ammunition. Nothing was recovered, lordship. Nothing. And no any previous record also, lordship. He is a resident of Dhubri. He was arrested by Helm police station of Biswanath, lordship.
You are named in the FIR. Are you named in the FIR? Yes, Mr.
Yes, Lordship, if I look into the forwarding report also, Lordship,
Forwarding
There is-
report is at which page?
11, Lordship.
Lord, the main accused has been released on bail, lordship.
Who has been released?
Sinjason Balte alias Sonpu, on whose custodial integration the accused name was taken, lordship.
Where is the bail order?
Below the protection. bill.
I don't have to bring it, lordship.
By which court he was released?
It's lordship, in the court below. Lordship, it's a court of lordship, judicial magistrate, first class Gopur.
No, from where we will come to know that he has been released?
Lordship, in the lordship, page 14, lordship, I have annexed the election order. There it is written, being so the accused person, namely Nukman Ali, is allowed to go on bail of rupees 15,000 with one suitable security of the like amount in default in remain in jail custody as page 14 last para.
Lukman Ali has been released. And who else has been released? You were naming some other accused persons.
Lordship, this Sinjason Balte alias Sonpur, lordship,
Singh,
it was said by my client, lordship.
Where is his name, whom you are addressing?
Lordship, that was told by my client, Lordship. I don't know from which court he was.
But how we will come to know that he is?
Client wife.
No,
was included.
no. Apart from that, is he named in the FIR? He is neither named.
In page 10, the FI is there.
You are referring to some person, name is Walte. No, who has been released on bail?
Lordship, on FIR's laws on 12/1/2025
Yes.
by SI Police of Helen Police Station, that it came to light that some individuals, 3 persons, that they are.
Who are those 3 persons?
Out of investigation, the accused name came to light, Lordship. 3 persons were arrested after that, Lordship.
Who are those 3 persons?
The other persons are Lordship Rizukan Pegu, Lordship
Yes.
Ratnakan Pegu.
And where is the name of the accused whom you were referring to?
Their names are also not here in the FIR, Lordship.
Neither in the forwarding.
Yes, they arrested, Lordship. And these 3 persons were arrested after interrogation. Police came to light and arrested many persons. In the forwarding itself, it is given. And I was arrested from Dhubri, Rahul Amin.
With King Jason Walte.
Other accused, I won't be able to say, Lordship.
Okay. No, he has been released on bail. That is your submission.
Yes, one Lukman Ali was released on bail.
Rukman Ali as well as King Jason
Page 14.
Walte also. Yes.
Yes, okay, if you look into the sections, Lordship, one of the section is 111, 111 within the bracket C3, Lordship. So this is an organized crime, Lordship. And in regard to that, Lordship, these persons were already involved in many other cases, Lordship. And in one of the case, this is the person named Singh Ja Shun Walte. That is Sonu, Lordship. He is the sharpshooter, Lordship. He has been hired. He is from Manipur, Lordship. And he was also charged in one case, Lordship, regarding the same facts, Lordship. And moreover, so the 113, that is organized crime, comes into play, Lordship. And moreover, he is also.
No, what are the materials against
Lordship,
Rahul Amin?
He is one of the mastermind, and all of the accused persons has himself they stated
Lordship,
that. Lordship, may
Let-
complete,
let-
may I complete. All of them has co-accused has implicated them, and one of the accused also who gave them shelter, Lordship, to this person. He also named him, Lordship. He has helped him in harboring, facilitate the crime, Lordship. He also stated that he came to his house and he sheltered him, Lordship. And he himself also stated, and other persons also stated, Lordship.
Whether it is stated in somewhere in the statement, yes, indeed.
Yes,
Because,
okay.
because
It is
nothing
stated
was
in the
because
statement.
he's from the client, Lordship.
It is in the
And Lordship
statement,
is a page 61, Lordship,
He
61
himself
2
also stated, Lordship.
is a criminal conspiracy. At 392(3), criminal trespass and house trespass. And note of section 1111, 113, it's an organized crime, Lordship. But nowhere there is reflected, and the punishment is only 5 years, Lordship. Which may.
Heard Miss B. Gogoi, Appellate Counsel for the petitioner. Also heard Mr. K. Das, London Additional Public Prosecutor. This application under section 483 of BNSS has been filed by the petitioner Ruhul Amin, who has been detained behind the bars 15/6/2025 within bracket for last 52 days in connection with LMPS case number 3/2025 under section 61 within bracket 2 within bracket small a / 329 within bracket 3/111 within bracket 3 of BNS read with section 25 within bracket 1 capital A of Arms Act. The gist of accusation in this case is that on 12/1/2025, one Molilur Rahman, one M. Rahman, SI of police, had lodged an FIR before the officer in charge of Helem police station, inter alia, alleging that during from local investigation, it came to the light that some individuals, namely Riju Kant Pegu, number one, number two, Muhammad Ali Hussain, and Rana Kant Pegu, along with some of their associates, have been illegally hunting rhinoceros for their horns in the Goimiri forest area near Brahmaputra River. It is also alleged in the affair that said Ratnakanta Pegu had procured illegal weapons and had been in contact with sharpshooters from Dimapur. Learned counsel for the petitioner submits that the petitioner is in no way involved in the offense alleged in the affair. She submits that the petitioner has not been named in the affair and he has been implicated in this case mainly on the basis of statement made by the co-accused persons. She also submits that nothing was seized from the possession of the present petitioner and he has been languishing behind the bars for last 52 days. She submits that considering the above facts, the petitioner may be. She also submits that in the meanwhile, two of the co-accused, namely Chinzason Walte, Chinzason Walte, alias Songpu, and one Nukman Ali have already been granted bail have already been enlarged on bail. She therefore prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the petitioner has been associated with the offense of poaching in other cases also. And there are materials in the case diary against him. He submits that the co-accused persons have implicated the petitioner in the offense alleged in the affair. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. You give me the case diary, flag the implicated. I'll go through the case diary and pass order. You see the order later on.
Item 22.
I was arrested in PS case 499. After arrest during interrogation, my house was checked, Lordship. Thereafter, an arms ammunition, two live arms and some dead ammunition was found, Lordship. Thereafter, this case was registered as 503. And I was shown arrest. Thereafter, I'm 357.
When you were shown arrest,
11/6, Lordship. But you would find that at page 20. 20, Lordship 22. Now, Lordship, main grounds of arrest for this case has not been provided to me.
where is the order of showing you arrest? Yes, Mr. Bora.
Yes. Lordship, order of shown arrest, the Lordship would see
Or
page
on
24.
24.
24, Lordship.
Case diary is there.
Yeah. 25, to be precise. 24.
Is it 24 or 25?
Lordship 24, hence the prayer of IO.
This prayer is for remand of the accused. Where is the order of, on what basis you are saying that he has been shown arrested?
Because Lordship, I was already arrested in 499, for which I have been.
No, where is the order? You go through the record. You answer my query. We'll take it up after some time.
Yes, sir. Maybe it is not annexed. I'll just.
Or on what basis you are saying that you have been shown arrest in this case?
499, I was already arrested.
Yes.
Thereafter, Lordship, again, after investigation, 50 PS case 503 was registered here. Thereafter,
Was there a prayer for the prayer from the IO for
Lordship,
showing you
yeah,
arrest?
whether I have annexed it or not, Lordship, let me take, Lordship, may take it after
Okay,
some
we'll
time.
take it up after something.
Item 23.
May I please before Lordship, I'm paying for a short passover. Mr. Speaker, stepping for the petition.
Okay, after something.
Item 24.
Lordship, civil appeal, Lordship. I'm praying for a passover for the time.
Okay.
Item 48 from supplementary list.
The Lordship scan copy was called for.
Scan copy received. No. None has appeared for the petitioner on call. Mr. B. Sharma Lanitka, additional public prosecutor, is present. On perusal of the office note dated 14/7/2025, it appears that the scanned copy of the trial court records has not yet been received. Issue reminder for the same. Release this matter on 21/8/2020.
Item 50.
The Lordship, we have taken the instruction, Lordship, amicus may be appointed.
The notice was served.
Yes, it was served, Lordship.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he has been informed by the officer in charge of jurisdictional police station that the notice issued to the respondent number 2 has been served. the stop, none has appeared for the petition for the respondent number 2. Hence, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. M.K. Brown, whose name appears in the list of amicus curiae, is hereby appointed as amicus curiae to defend the cause of respondent number 2. The petitioner is directed to furnish a copy of bail application along with the annexures to the on 21.
21 of this. Well,
Item 51.
Lordship, I kindly take it up after some time.
Here, I have a small prayer, Lordship.
Yes,
Your Lordship, this is the third or fourth bill application, Lordship.
by the same accused.
Yes, and Lordship, the earlier bill application, the grounds of 47, 48 were taken, and that was rejected by the coordinate bench, Lordship. Now, Lordship, this case was
Which one is that court?
order. That is, Lordship, find at page 80, Lordship. From, I'm sorry, from 77 it started.
Now, what is your submit?
My submission is, Lordship, this case was at that point of time taken up by PS law for Lordship. So I may be allowed to just, he may be allowed to submit on the behalf.
He is not present today.
He's in another court. So if any other date is fixed, Lordship.
Lordship, let my senior be present here. She might have to submit something.
You submit.
Lordship, I do not.
They are see, they are no, they are not, he's not submitting on merit. He's submitting that as this matter was dealt with by another.
If he can appear after some time, we can do the hearing today.
No, it is exactly my submission for hearing only, Lordship, and submit. If any other date is fixed, Lordship, I will ask him to appear, Lordship. Even tomorrow is fine.
Lordship, we are also on the merits of the case. Our guns is not only section 50.
11th. On 11th. Heard Miss
And Sultan.
N. Sultana, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that this matter was earlier dealt with by another additional public prosecutor, namely Mr. P.S. Lakhar, who is on legs in a different court. He therefore prays for a short adjournment. Considering the grounds considering the grounds submitted by the petitioner and by the additional public prosecutor, the prayer is allowed. Let this matter be listed on 11th.
I'm obliged.
11th August.
If 5 Lordship, Shakti has been submitted.
wait, interim.
Is there in
Shashik submitted, Lordship.
you cooperated?
Yes,
You
I
appeared.
did. As per my instruction, after interim order, I appeared.
Heard Mr. N. Mahajan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
117 dated 29/6/25. 117 dated 29 June 25.
learned counsel for the petitioner submits that the petitioner was granted interim bail by this court on 13/2/2025. And in pursuant to the directions of this court, he has cooperated in the investigation. Considering the submissions made by learned counsel for the petitioner, the interim bail granted to the petitioner by order dated 13/2/2025 is hereby made absolute, subject to the condition that he shall cooperate in the trial. This bail application is accordingly disposed.
PD has been received, Lordship.
What happened? Are we moving too fast? We will wait for some time.
Item 28.
Please, Lord. What if CD was called for in the previous?
Case diary is there. Yes, what is the submission?
Submitting it, my lord, there was no involvement on me, Lordship. I was given a summon to the by the police, but Lordship, they give me a summon on the day of Eid, Lordship. So on that day, I could not be present, but however, I sent a formal representation, Lordship. Page number.
You received a notice under 35(3).
Yes.
What is the case? What is the allegation?
Allegation is that, Lordship, let me read out the FIR. One Izahar was submitted by one Samsul Hawk that oil was being stolen from the nearby refinery. The FIR is at page number 9. In the relevant portion. Page number 14. With reference to the above, I have the honor to inform you that today at 4 a.m.
What is your name? Name of the petitioner?
Petitioner is Lordship Muhammad Moniruddin.
You are named in the FIR.
No, Lordship. I have no direct involvement, Lordship. But Lordship, during the course of the investigation, I was issued summons. But however, Lordship, they called me on the day of Eid, Lordship, for which I couldn't go, and even I sent a representation to the IO concerned that any other date may be possible.
Then what happened?
Then, Lordship, they have come to arrest me, Lordship. But however, I was not at the home during the time.
Yes, Mr. Parag.
Lordship,
My lord, one Bolero pickup van with some empty drums and 7 drums with full loaded with diesel. 50 liter each, my lord, were seized. And my lord, some persons, my lord, they stolen those diesels from the railway wagon, my lord, that then come from the Bongaigaon refinery. And in this process, my lord, several persons were involved, my lord, though there are only 3 names, 2 names and 1 driver of the Bolero pickup. Petitioner also one of those, my lord. He, as per the statement of the other persons, my lord, he is also involved in stealing the, my lord, diesels from. And they,
What is the statement against him?
other persons stated that co-case stated that he, along with the other persons, also involved, and they stole those diesels from the trains and stole it in the nearby market. And
sir,
this
not
is-
true, my lord. I am from Barpeta and the place of occurrence is at Bongaigaon, Lord. But the petitioner itself is from Barpeta district. My lord.
Who has named him? Specifically named.
My lord, yes. Moinuddin name is there.
Do you require his custodial interrogation?
as now notice given.
What's interim is granted lordship, we are ready to cooperate.
Why interim?
Lordship, we couldn't appear during the date of summon lordship, just because of the occasion of Eid, my lord.
Okay. Heard Mr. N.J. Doimari, the learned counsel for the
It
petition.
is mentioned that from Moinuddin from Borpeta is working, my lord. He is from Borpeta, but he is along with them, that is mentioned by the court.
Also heard Mr. K.K. Parashar, learned counsel for the petitioner. Learned ready. আরম্ভ করেছি। Heard Mr. N.J. Doimari, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Muhammad Monir Uddin, who is apprehending his arrest in connection with Bongaigaon PS case number 40/2025 under section 61 within bracket 2/303 within bracket 2/317 within bracket 4/317 within bracket 2 of BNS, read with section 23 of the Petroleum Act. 23 of the Petroleum Act is, what is the punishment? Is it bailable or not?
Not available, but punishment I'll confirm that.
Petroleum Act. The gist of accusation in this case is that
No. Yeah.
that on 12/2/2025, one Bhupen Rabha, ASI of police, had lodged an FIR before the officer in charge of Bongaigaon police station that an information was received on that day that one Abed Ali has been selling stolen diesel from his house on getting the information. When the VDP party proceeded to nab the culprits, they escaped, leaving behind one scooty bearing registration number AS2606 AS26D6718 and one Bolero pickup van bearing registration number AS26C7817. On search of the said Bolero pickup van, 10 numbers of empty plastic drums were found therefrom, and it was stopped later on from the house of Abed Ali. 7 numbers of diesel, 7 numbers of drums filled with diesel were recovered from their stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in this case. It is submitted by learned counsel that the alleged offense occurred in Bongaigaon district, whereas the petitioner hails from Borpeta district. He also submits that the petitioner received a notice under section 35(3) of the BNSS for appearing before the investigating officer on 7/6/2025. However, as due to some personal difficulty, as on that day, it was Eid festival, he could not appear before the investigating officer, and he sought leave for extension of time from the investigating officer. Stop. The learned counsel for the petitioner submits that no extension of time was communicated to him. Rather, the police came to his house for his search. Police came to his house searching for him, and therefore he is apprehending that he may be arrested in connection with the above noted case. He submits, learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. Stop. On the other hand,
Section 23, 1 month for the first time,
available.
Not billable.
otherwise in
Billable or
subsequent-
1,000 fine.
subsequent occasion only 3 months.
Learned additional public prosecutor has produced the case diary of Bongaigaon PS case number 40/2025 and has submitted that some of the witnesses who have been examined by the investigating officer have implicated the present petitioner. You are opposing or implicated the present petitioner? Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Since the investigating officer had issued notice under section 35(3) within bracket 3 of BNSS, and since the petitioner has defaulted in appearing before him according to the said, in pursuant to the said notice, he has a genuine apprehension of getting arrested. However, on perusal of the case diary, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of investigation in Bongaigaon PS case number 40/2025. In view of above, this anticipatory bail application is disposed of with an direction to the petitioner to appear before the investigating officer of Bongaigaon PS case number 40/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2.
Highly grateful, madam.
Send back the case.
My lord, I'm sorry to interrupt, my lord. My lord, already passed order in item number 51, lordship. Lordship, because Learned PP B. Sharma could not appear today in the case, lordship. Learned PP has submitted that question. So lordship, fix the matter on 11. Can it be on, can be tomorrow or day after tomorrow? Because I took consent from Mr. Bill.
We have lot of cases. It may not be possible.
Possible then today at 2, lordship.
No, it is not possible. Mr. Locker will be coming at 2.
Only in one matter, there is
No, order has already been passed. You wait till when it was
11th.
11th is not far away. Wait till 11th.
he is suffering some problem because of gunfire, shot fire received by, at the time of occurrence, lordship. That
But-
he is well.
He's under treatment.
Though under treatment, my lord, some problem is there, lord, that is why, lord.
Wait till 11th.
Obliged.
Item 29.
Wait, please, your lordship. Lordship, this is an anticipatory bail application. Here the petitioner FIR on page 15, lordship. Informant and the petitioner known to each other, lordship, and the petitioner borrowed lordship 60,000 for treatment of her mother, lordship. Later refused to pay that amount, lordship, by saying, lordship. Accordingly, lordship, case was registered under cheating and breach of trust and conspiracy, lordship. And on that FIR, lordship, he has approached before the court below, lordship, and court below has rejected his bail prayer on the ground of, lordship, cheating by personation, lordship. This cheating by personation, lordship, 319 is a bailable offense, lordship.
Where is the rejection order?
That is on page, lordship will find on page 17, lordship. On page 19, lordship, it is there, lordship. Otherwise, lordship, 35(3) notice was not issued, lordship. In this case, lordship, offense, lordship, punishment.
When were you arrested?
Arrested, lordship, anticipatory bail, lordship.
Anticipatory bail.
Yes, lordship. 35(3) notice was not issued, lordship. And moreover, lordship, this petitioner signed in a Hindi, lordship. The FIR was written in English. Well drafted FIR, lordship. Only thing 60,000, lordship, he has taken, lordship. Now he is in run, lordship.
60,000 taken as loan.
It was also for her mother treatment, lordship.
But it is half truth, lordship. Lordship may go into the later part of the FIR.
That is exaggeration, lordship.
That's half.
Read the affair. What is the accusation against you?
With due respect and humble submission, I would like
Yes,
to.
that is there.
Luckily, there is there.
With due respect and humble submission, I would like to lodge an FIR against the accused person, Raju Ali, for dishonestly cheating me. And approximately 3 months ago, I visited my aunt Chachi's Parvati Devi at Guwahati. There I meet Raju Ali, whom I already knew. And he had previously worked in our area at Pul Pahad, Uttar Pradesh, as a driver. When I meet him at Guwahati railway station, he told me that his mother was seriously ill and urgently need money. He asked me if I had any money. Out of sympathy, I agreed to help him and handed over an amount of rupees 60,000 in cash. He assured me that he would return that amount within 3 months. Recently, when I tried to contact him to get my money back, I reached out to him on his phone number. When I tried to contact him to get, I reached out to him on his phone number, such and such. He told me to come to Guwahati and to collect the money and asked me to meet him at Rongia railway station. When I reached there, instead of returning that money, he gave me a gold like a square piece and told me to sell it and recover the money and pay him the remaining amount. I refused to accept it and told him clearly that I only want my money back. Then he showed me another boat shape gold colored item and told me to wait and at the station. Well, he sold it and returned with the money. However, he never come back and kept waiting for a long time. Later, he asked me to come to Lakhimpur and share a photograph of his video voter ID via WhatsApp. Asked me to meet him at Bihupodia, assuring me that he would return the money. I was also show a photo of the same boat shape gold item on the WhatsApp and was told that it would be handed over to me. He also gave me another phone number such and such, saying it belongs to his brother. When I contacted him, this number, the person identified himself as a Rahul, and both he and Raju Ali kept contacting me regarding the same gold item, but have not returned the money. On 24/5/25, both Raju Ali and the person claiming to be his brother Rahul contacted me and asked me to come at Bihupodia and meet him near the Bihupodia circle office, stating that they would hand over the gold piece and that had previously been shared with me on my WhatsApp. Sir, I am the resident of Pulpahar.
Mohabbat district, Uttar Pradesh, and I have been left wandering here and there in Assam for the past 8 days without money and unable to return home. I have been mentally harassed and financially cheated. This
Where is that portion in the rejection order where it is mentioned by the trial court that it is?
Lordship, it's
due
page 18, Lordship.
You are Shah Jahan.
Yes, Lordship, Shahjahan.
Same person, Shahjahan and Rahul, Raju.
Page 18, paragraph 8, Lordship. Misrepresented 9, Lordship, the same and one person, he has falsely represented his identity by using his name Raju Ali before the company.
This is basically a case where loan was taken. And
35(3) notice is not given, Lordship. Otherwise, Lordship, we will.
what is your submission?
In my submission, Lordship, this is a fake gold, Lordship, although FSL is, has not been received, Lordship, it is suspected to be. And moreover, Lordship, he has been in contact with this person, Lordship, this victim. And the statement of the person who brought him to that place, Lordship. And when police came, he ran away, Lordship. Even it is a pure gold, Lordship, he should not have,
Let him appear.
Lordship.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Shah Jahan Ahmed, who is apprehending his arrest in connection with Bipuria PS case number 107/. Why are you apprehending your arrest?
Because of Lordship, police is after this petitioner, Lordship, and my bail, anticipated bail has been rejected by the court below, Lordship.
No, that cannot be a ground
But
for.
only because of Lordship, I'm ready to return that amount, Lordship. Now I'm on run, Lordship.
That is not my question.
Yes.
My question was, why are you apprehending arrest? What made you come to the,
Because of Lordship, this Lordship,
whether
yes.
police is searching for you?
Yes, Lordship, the police is searching this petitioner, Lordship.
Arrest in connection with Bipuria PS case number. What is the maximum punishment for 3184,
It says 7 years, Lordship, I'm not wrong.
3162? Bipuria PS case number 107/2025 under section 318 within bracket 4/316 within bracket 2/3 within bracket 5 of BNS.
7 years, 5 years, Lordship. 3184, Lordship, 4, 7 years, and 3162 for Lordship, extend up to 5 years.
The gist of accusation in this case is that one, Ram Kumar, on 24/5/2025 had lodged an FIR before the officer in charge of Bipuria police station, inter alia, alleging that you are Raju Ali,
I am Shahjahan Ahmed, Lordship.
inter alia, alleging that one Raju Ali was given 60,000 rupees by the informant out of sympathy on the ground for treatment. 60,000 by the informant for treatment of his mother. However, treatment of whose mother?
This Raju Ali's mother, Lordship. as per FIR, Lordship.
Stop with a promise to return the same back. Return back the same within 3 months. However, same was not done. Instead, he was given a boat-shaped golden metal and was requested and was asked by the said Rajoli that same may be sold by the informant and the loan amount may be realized. That golden boat was given or not given?
They will can say, Lordship.
No.
No, Lordship, this petition has not given anything.
Only last time products. No, instead, he was given assurance that he would give some gold item which he may sell and realize the money. However, and he was asked to wait in Rongya railway station. However, on the said date, the said Raju Ali and his associate Rahul Ali did not turn up. Learned counsel for the petitioner has submitted that petitioner is apprehending his arrest as police is searching for him. He also submits that. What is your submission regarding the acquisition? You took money.
That is, Lordship, I am admitted, Lordship, the 60,000 he has been taken, Lordship, not by saying I am a Raju Ali, Lordship.
Okay. He also submits that the petitioner he took money from the informant. However, if there is a dispute regarding that, it would be a dispute dispute of civil nature, and the FIR has been lodged only for pressurizing the present petitioner. He submits that the petitioner is ready to cooperate in the investigation. On the other hand, that golden boat was given.
And it is stated in the seizure list is there, Lordship.
From whom
the-
it was
from
seized?
the complainant, and it is also stated that it is given to Rajkumar by Raju Ali. It is there.
Then, on the other hand, learned additional public prosecutor has submitted that has produced the case diary of Bipuria PS case number 107/2025 and has submitted that in this case, the accused Raju Ali and Shahjahan are same person.
Same, Lordship.
In that regard, Lordship, I
Impos-
file an additional affidavit, say, Lordship, I am
Lordship,
Sergeant.
it came to be known only when the person with whom this person came, if this person, he stated that these are the same person. Then only it came to be known, Lordship. These are the two persons.
Then additional public prosecutor submits that Raju Ali and the present petitioner are the names of one and the same person. And it has been revealed during investigation that in fact, Raju Ali gave a golden boat to the informant which is suspected to be fake gold. He also submits that the sample of the said suspected gold has been sent to the forensic laboratory for examination, and same has not yet been received. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which has been produced by the learned additional public prosecutor. On perusal of the case diary, it appears that the main accusation, the main dispute between the parties is regarding non-repayment of loan availed by the present petitioner from the informant, which is predominantly in the nature of civil dispute. As such, this court is of considered opinion that if the petitioner cooperates in investigation, his custodial interrogation may not be necessary for fair completion of the investigation. Accordingly, this anticipatory bail application is disposed of with a direction to the above named petitioner to appear before the investigating officer within 7 days from the investigating officer of Bipuria PS case number 107/25 within 7 days from the date of this order, and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. This, and send back the case then.
Highly obliged. Always.
May I please, Your Lordship? Lordship, your allegation in the FIR is basically seizing of a contraband from the vehicle wherein the petitioner is the registered owner of the vehicle. But the fact is that the petitioner has already handed over the possession to another person prior to that incident, my Lord. My Lord will find the FIR at page 16. May I read, my Lord?
Yes, page 16.
Page 16, my Lord. With reference to the subject.
To whom you have handed over?
My Lord, one person, Saddam Hussein, my Lord will find the agreement at page 22, my Lord.
Saddam Hussein.
It was executed on 29, my Lord, 29/01/2024, and the contraband has been seized on 14/02/2024.
Where is the affair?
FIR, my Lord, page 16.
Yes.
With reference to the subject cited above, I have the honor to report you that as per daily routine checking, a NACA was placed at NACA checkpoint of Churaibari outpost, watch post on NS 808. The composition of the NACA was follows: so and so, so and so, so and so. At around 10:30 AM, 14-wheeler turmeric yellow color Ashok Leyland Bharat stage 6 model open body truck bearing registration number is 28 SE 0530 was found standing near the NACA checkpoint on National Highway 8, and it can be seen that the driver of the truck escaped from the spot by taking advantage of heavy traffic and leaving the truck behind the checkpoint. It was suspected that something narcotic substance may present in the vehicle. So I immediately informed to my superior officers about the matter also. Officer in charge Bajarichera PS about the matter over mobile phone. At about 10:40 AM, I sought authority letter from so-and-so to conduct search.
What was the contraband?
My Lord, fancy dial.
How
of
much?
178 numbers of cartons.
17,800 bottles, my lord.
What is your case?
My lord, my case is basically, I didn't have any knowledge.
You are the registered owner of the
Yes,
vehicle.
my lord. I might be a registered owner, but already the position of the truck was already handed over to some other person. That day, it was not under my possession, number one, my lord. And it was, if you lordship, have a look at the last paragraph at page 16 itself. During search, a huge quantity of so and so phosphate, cough syrup, fancy dial were found hidden inside small size rock and onion bags. It was hidden inside the onion bags. The so and so fancy dial were packed on so and so. So after completion of search process of the said vehicle and below mentioned so and so were recovered and seized. So here, the presumption under section 35 also cannot be drawn, my lord. As the strength of the proof is, it should be beyond reasonable doubt, not a preponderance of probability, my lord.
Where is that you have sold?
My lord,
What happened to Saddam Hussein?
my lord, nothing.
He's also an accused.
My lord, no, I don't think so, my lord. He is not the accused, my lord, because the petitioner couldn't.
He has been granted bail.
No, my lord, the truck was not seized in abandoned, the driver fled away. Driver, no one was there, my lord. Only
And-
the fancy dial bottle, 17,800 bottles and 750 kg of onion.
And this section notice, my lord, under section 67 has been served upon me after filing this instant bail application, my lord.
Police came to know about.
After 1.5 years, my lord, I received this, my lord.
No, we have dealt with a case of co-accused in this, I remember.
Yes, my lord. I have the order, my lord.
Which,
My lord, 2 orders. One is your lordships and one is the coordinate bench, my lord.
in this case,
Similar case, my lord.
not similar. In this case,
In this case, no, my
In
lord.
this case, no. One is there.
I remember
Yes, one is there.
one accused has been granted bail.
Take correction. Bazar Sara 33 of 24. Yes, my lord, someone is there.
Saddam Hussein,
I have
Yes.
granted us.
AB once. That co-accused has admitted that he purchased it from Renal Pathak. I'll verify. You verify?
I'll verify after some time, my lord.
Okay, the case number is AB 1517 of 2025. Disposed of on 8th of July. There must be some indication in the case diary.
AB 15 of the 1577.
1517.
I see. Give it to me.
But I'll go through and.
You go through that
Lord, my lord.
and make submissions later on.
Much obliged.
This case, my lord, trial court record also is on January, my lord. So up to date, TCR may be called for that.
No, Lordship, on the last occasion, Lordship has already made up the mind for dismissing the bail application, Lordship. Earlier rejected by your Lordship.
Because my
There
lord,
are no new ground was taken, Lordship. All those grounds has already been considered by your Lordship.
my lord, this bail application was filed on
If
March 12th, my lord. Much
If
earlier.
Lordship kindly peruses the last order, Lordship will see, he was supposed to cite some judgment in the support of his contention. Lordship.
What contention? What was your contention?
Contention, my lord, whether I was not the possessor of that contraband. Because I was not at home. I was at Aizen, my lord. This was my view, my lord. And my wife was staying at a rental home, my lord, where the owner of the house was not made as an accused. And I was at Aizen.
Oh, search warrant.
search warrant regarding.
Now you took
So
plea
my-
that's,
my humble-
it was without search warrant.
To know the present stage of the trial, madam, whether the evidence is taken or not, whether, because this case was filed on March and 9th of May. And today is the minor August is going on. Subsequent, what happened, madam, and record come from January, madam.
No,
Thereafter, no update.
what is your plea?
Three plea, madam.
It was found from your residence. Your wife was
I'm
there.
saying not from my residence.
That we will verify from records.
She was already made an observation, if I may just point out. Lordship.
So, my lord, if
Uh,
after this PCR will be called for, then we may go to the
No,
whether charge is framed or
You
not.
have to be honest while making submissions before court. On last occasion, you took a different plea and took leave from this court that you will bring authorities in support of your submission. You took the plea that in INDIPES cases, such cannot be made without warrant.
Can be that section 42 is there.
That plea you took. Therefore, I reflected in the orders. And you sought some time for producing some authorities. Today, you forget about that submission and making a new submissions. At least you have to remind the court that why you to, had I not reflected it in the order sheet, you have to make some submission what happened, or you are not pressing that plea.
My lord, I have a submission that I'm placing that plea only that I was not the possessor of that contraband. So, my lord, the Tufan Singh come into existence. I was protected under Tufan Singh judgment. Since I was at Aizol and I have some dispute with my wife, wife is staying at a rental home and saw that I could not found at home because I was at Aizol. So if something is found at a rental home where my wife was present, then I cannot be implicated in this case, madam. In this was my plea, madam. And also, my co-accused have been granted bail earlier, my main accused, Juvenility, who has been granted bail. So, my lord, to know the present status, if PCR is come up, and my lord, that will be better for us to dispose of.
No, why are you seeking the present status? You are not seeking bail on the ground of prolonged incarceration.
Because I was arrested on execution of a warrant. On execution of warrant, I was arrested.
Okay, what will happen if you know about the status of the case? How it will help your case?
Because I was arrested in the month of December or January, so already 7 months have been elapsed. Although I was not the possessor of that contraband. So, and the main accused have been granted bail. So under that present circumstances, my lord, I may be granted bail. So if we know the present status.
No,
the
no,
charge
that is
filed.
not relevant. Status is not relevant for it.
Otherwise, my lord, I cannot be taken the possessor of that contraband because I was at Aizol, my. So should I be implicated should I be treated as a possessor of that contraband?
You are ready for making submissions today.
Maybe some other day, my. And if up to date, my status report will be called for, that will also better. for us.
Status report will not assist you. If you are not ready, we will adjourn it.
Right.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner prays for an adjournment on the ground that he is not ready to make submissions, fully prepared to make submissions today. And stop considering these submissions made by learned counsel for the petitioner. This case is adjourned for today. List it. When do you want it?
19th of August.
On 19th of August.
Item 14.
Please, the lordship.
Yes.
The petitioner was arrested on 27/9/2022. As on date, 2 years, 10 months and 10 days. Lordship. Charge sheet was filed on 21/3/2023 and charge was framed on 18/11/2023. Total 11 witnesses, Lordship, out of which 7 has been examined till now. My ground for bail is ground of arrest not communicated to the petitioner and prolonged incarceration and ground of arrest.
Yes, Miss Dekha.
Lordship, here, Lordship, first of all, Lordship, already 7 witnesses have been examined. Lordship, as per my instruction, only IO is left. Lordship, in between, Lordship, IO appeared, Lordship, but he could not be examined, Lordship.
No, if 7 witnesses have been examined, then 4 are still remaining.
2 or 3 are independent witness, Lordship, they are not found. Lordship, as per my instruction, only IO is left, Lordship. And Lordship, regarding parity, Lordship, they cannot seek parity because Lordship,
Grounds of arrest?
Lordship, ground of arrest, Lordship, that he contraband was recovered from him, from his conscious possession. And at the time of his arrest, he accepted arrest memo, Lordship, and his signature was there, Lordship, in the arrest memo, Lordship. And he was arrested on, Lordship, 27/9/22, Lordship. Lordship, regarding parity, they cannot seek parity, Lordship, because yes, Lordship, bail was granted to co-accused, but nothing was recovered from them, Lordship. But here, Lordship, petitioner was caught red-handed, Lordship.
Heard Miss J. Singh Fo, learned counsel for the petitioner. Also heard Miss M. Dekha, learned counsel for NCB. This application under section 483 of BNSS has been filed by the petitioner, namely, what is the name?
Alinder Ray, Lordship.
Namely Alindra Ray, who has been detained behind the bars since
27/9/2022.
since 27/9/2022, within bracket for more than 2 years, 10 months, in connection with special NDPS case number
36 public
36/2023, corresponding to NCB crime number 21/2022 under section 20B2C/29 of NDPS Act 1985. Presently pending before the Court of Learned, Additional Session Judge number 5, Kamrup Mitra Guwahati. Gist of accusation, Court Para 3, 4, 5, 6, from page 70 of the bail application. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on 2 counts, namely the grounds of arrest were not communicated to him when he was arrested in connection with the above mentioned case, which amounts to violation of his fundamental rights guaranteed under Article 22(1) of the Constitution of India. Learned counsel for the petitioner has also submitted that the petitioner has been languishing behind the bars for more than 2 years, 10 months. And such a prolonged incarceration has infringed his fundamental rights guaranteed to him under Article 21 of the Constitution of India. She also submits that in the meanwhile, four of the co-accused persons,
Co-accused lordship.
5 of the co-accused persons have already been granted bail. Stop. On the other hand, Ms. M. Deka Lanin, counsel for NCB, has opposed the grant of bail to the present petitioner on the ground that the contraband seized in this case is of commercial quantity and the embargo of section 37 of the NDPS Act is applicable to this case. She also submits that the petitioner cannot be granted bail on the ground of parity that the other co-accused have been already enlarged on bail, as much as he stands on a different footing, as the petitioner was caught red-handed with the seized contraband. So she also submits that as far as she also submits that though 4 more witnesses are yet to be examined, however, out of those 4 witnesses, 3 are independent witnesses whose attendance could not be procured by the trial court, and therefore only investigating officer remains to be examined in this case. He submits that as the seized ganja was recovered from the truck which was driven by the present petitioner at the time of its recovery, he was aware about the grounds for which he has been arrested in this case, and therefore there has been no violation of his fundamental rights guaranteed under Article 22(1) of the Constitution of India. Whether notice was given to you?
102, page number 102.
Stop. She submits that as notice under section 40,
50.
section 50 of BNSS was served on the petitioner when he was caught red-handed. This amounts to sufficient compliance of the constitutional mandate. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the case record of NDPS case number 36/2023, which was requisition in this case, in connection with this case. On perusal of the notice served on the petitioner under section 50 of BNS, under section 50 of CR, Code of Criminal Procedure 1973, it appears that same is devoid of any grounds of arrest or basic facts which necessitated the arrest of the present petitioner in connection with the above mentioned case. It also appears that though the petitioner has been languishing behind the bars for more than 2 years, 10 months, however, till date, only 7 prosecution witnesses out of 11 listed prosecution witnesses have been examined. Quote para 24 from page 74. 24, 25, 26, 27. Seven 29, 30, change the time. 30, 30, instead of 2 years, 4 months, make it 2 years, more than 2 years, 10 months. 31, no, 31 or ago 43. This court also does not agrees to the submissions made by learned counsel for the NCB that when an accused is arrested red-handed with the contraband, the mere furnishing of a bold notice under section 50 CRPC without mentioning therein the basic facts which necessitated the arrest would be due compliance of the mandate of Article 22 within bracket 1 of the Constitution of India. Stop. Such an interpretation will dilute the effect of dilute the provisions of dilute the constitutional provision as contained under Article 22(1) and as interpreted by the apex court in Vihan Kumar Dioksu in the case of Pankaj Bansal versus Union of India, reported in 2024, 7 SCC 576, Prabir Purkasa versus State and City of Delhi, reported in 224, 2024, 8 SCC 254, and Vihan Kumar versus State of Haryana, reported in 2024, SCC online. Vihan Kumar versus State of Haryana, reported in 2025, 5 SCC 799. Stop. Next, quote para 31. Quote para 32. 1 lakh with 2 sureties of like.
I,
Item 23. Item 23.
Yes,
My lord, 483 application, my lord. Date of arrest is 8/6, my lord. The allegation is by Sassit submitted,
charge sheet submitted,
my lord.
appear before the trial court. Heard Mr. A.C. Bishwas, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
08/25 dated 31/7/25.
sub. In view of the fact that the charge sheet has been submitted, this bail application is disposed of with an observation that the petitioner may approach before the trial court and may file regular bail before the said court, if so advised.
24.
There is a 483 application, my lord. Petitioner was arrested 37 days, my lord. Date of arrest is 1/7. I take your lordship to page 29, my lord, page 10, my lord, for FIR, my lord.
Yes,
It's 17. Lord. 17.
Page 17. There are 20 persons here. My lord, in the main case, my lord, that NDPS for which the police went, the lordship has allowed that petition because considering that a bailable offense. My lord, the police went to the, and actually in fact that they ransacked the shop of the petitioner, my lord. That's why, my lord, about 500 people objected against the police, my lord. Then, my lord, thereafter, my lord, they lost this affair and against the 20%, my lord. I do not know how they have collected the name. There is allegation that this arms was trying to snatch away, but he opened fire against to disperse the persons, my lord. This sections has been given, my lord, here. 61 is criminal conspiracy. And, my lord, 1921 is. Yes, sir. Maximum punishment is 2 years and fine. 193, guilty of rioting, being armed. May extend to 5 years or fine. 126, wrongful restraining this simple imprisonment for 1 month, for a month. Then 127, my lord, wrongful confinement of or more than extended for 5 years or fine. 132, the criminal force for public servant, my lord, from discharge of duties only non-bailable. And 262, resistance of the obstruction of the person and punishment up to 2 years, my lord. So, my lord, they are punished enough, my lord, they are behind the bar. I pray that at least, my lord, their bail will be considered. TD has come, I think.
yes.
This is the story, my lord.
That is the allegation. They restrain the officers from discharging their
But
duties, lordship, and
sufficient period.
lordship.
Heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely number 1, Ataur Ali, number 2, Imamul Haq, 3, Ghazibur Rahman, 4, Kitab Ali, alias Kitab Ali, 5, Abdul Qadir, who are detained behind the bars
From 1/7.
since 1/7/2025 within bracket for last 37 days in connection with Manikpur PS case number 71/2025 under section 61 within bracket 2/192 within bracket 2, 191 within bracket 2, 191 within bracket 3/126 within bracket 2, 127 within bracket 2/132/262 of BNS read with section 25 within bracket 1AB of the Arms Act. The gist of accusation. You are named in the affair.
Yes, 20% are named in the account.
The gist of accusation in this case is that on 29/6/2025, one Yasin Ali, UBC of police had lodged an affair before the officer in charge of Manikpur police station, inter alia, alleging that on receipt of an information regarding dealing of suspected heroin by some persons, a police team went to the cloth shop of one Sumar Ali and seized 2 plastic vials containing suspected heroin. When the police team was there, it is also alleged in the affair that when the police team was there, the owner of the shop instigated the local people from
To restrain the lawful.
from police arresting him. And thereafter, the accused persons named in the FIR, including the present petitioners, gathered there and started rioting and restrained the police officials in performance of their duty, and also snatched weapon from the officer in charge of police station.
Not officer in charge, madam, his security, madam.
Weapon from the PSO of the officer in charge of police station. Learned counsel for the petitioner has submitted that the petitioners have been wrongly implicated in this case. He, however, submits that the petitioners are languishing behind the bars for last 37 days, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail and has produced the case diary of Manipur PS case number 71/2025. Stop. He also submits that there are sufficient incriminating materials against the petitioners in the case diary. He, however, what is the progress?
Yes, some persons are yet to be arrested.
He, however, submits that the investigation has fairly progressed, though some of the co-accused persons are yet to be arrested. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. It appears that there are some incriminating materials against the petitioners in the case diary. However, considering the progress made in the investigation as well as period of detention already undergone by the petitioners, this court is of opinion that if the above named petitioners cooperate in the investigation, their further custodial detention may not be necessary for fair completion of the investigation of Manikpur PS case number 71/2025. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of Chief Judicial Magistrate Bongaigaon with following conditions. Number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Item 27.
Yes.
Sorry, my lord, don't take your own time. My lord, in this case, my lord, the FIR is lodged after 55 days of the date of incident, my lord. My lord, the FIR is final court penalty case 12 months.
And appearing for the respondent number 2, we will file objection, and yesterday only we have received the copy.
My lord, I am not in interim, my lord.
This is a POXO matter.
Yes. Approximately.
Okay. When will you file objection?
In some day.
How much? Let him file objection.
My lord, can you see the FIR for a moment, lordship?
No, let him file the objection.
We can file it.
Heard Mr.
Everything.
A. Hussain, London. You are appearing for the informant. Informant is victim's father. Father. Heard Mr. A. Hussain, London, counsel for the petitioner. Also heard Mr. B. Sharma, London, additional public prosecutor. As well as Mr. What is your name?
C. Boro.
C.
C. Boro. Yeah.
C. Boro. G. Boro, London, counsel for the informant who seeks some time for filing written objection against the prayer for anticipatory bail made by the petitioner. The time is granted. Let this case be listed again on 21.
My lord, if possible, my lord. 14, my lord. I am not in interim.
14, will it be possible? Why?
Diary is available. The diary is
21, 18,
not 18, my lord, then 19, my lord.
19.
Item 14.
Three zero.
I'm so grateful, my lord. So in that I have verified the order, and paragraph 4, the petitioner, the purchaser had candidly admitted that he had purchased that vehicle, says vehicle, from this present petition.
And in that petition, the statement of the petitioner was that, my lord, the driver told him that he is bringing onion. But in case of onion, my lord, this onion with along with this 7,800 bottles on. Now police came to know about this person because of the he's a
But for
registered.
last 1 year, you could not arrest either driver escaped.
Driver escaped.
Unless,
Who is driver? It is
unless driver is, and he has already sold it to some other person
Yes, my lord.
who has admitted.
No, that Saddam Hussein.
Saddam Hussein. Okay. Heard Mr. B. Deka,
PM deck.
BM Deka, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 has been filed. 482 of BNSS 2023 has been filed by the petitioner Shri Mrinal Pathak, who is apprehending his arrest in connection with Bajari Chera PS case number 33/2024 under section 22C/25 of the NDPS Act 2025, NDPS Act 1985. Gist of acquisition, quote para 3 from bail AB number 1575 dated 31/7/2025. ইয়াতে আছে রেকর্ডতে আছে Court para 3. Learned counsel for the petitioner has submitted that though petitioner is still a registered owner of still the registered owner of the seized truck. However, he had already sold the said truck to one Saddam Hussein and also handed over possession of the truck to said Saddam Hussein. And therefore the petitioner is not aware about what was being carried in the said truck after what was being carried in the said truck, as he did not have possession. He no longer had the possession of the said truck. Stop. Any other submission?
My lord, the knowledge presumption under section 35 also cannot be.
Okay, no, we will not go into merits.
Fine.
Now, why are you apprehending?
My lord, because I am the registered owner and the police has issued the notice under section 67 also.
When the date is fixed?
That is fixed on, my lord, within 7 days. I have received it on 25th July.
Learned counsel for the petitioner has submitted that the petitioner has received notice under section 67 of the NDPS Act from the investigating officer, and as non-bailable provisions of law, non-bailable provisions of NDPS Act has been involved in this case. He apprehends that if he appears before the investigating officer without any protection, he may be arrested. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Bajari Chera PS case number 33/2024 and has submitted that the contraband seized in this case is of commercial quantity and the embargo of section 37 of the NDPS Act 1985 is applicable in this case. Stop. He also submits that and the driver of the seized truck could not be arrested till date. And as the petitioner is the registered owner of the seized truck, only investigation would reveal regarding his complicity in the offense alleged in the case. Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary of Bajari Chera PS case number 33/2024. Court para 9 from the said case. Yes. It appears that one of the co-accused, namely Saddam Hussein, has already been granted anticipatory bail by this court on 31/7/2025. And said Saddam Hussein has admitted that he had purchased the seized truck from the present petitioner. Stop. Thus, at the present, at this stage, apart from the fact that the petitioner happens to be, still happens to be registered owner as the transfer of registration certificate has not yet been done, there is no other material in the case diary to indicate that the present petitioner has been involved in carrying the seized contraband, involved in any manner in carrying the seized contraband in the truck from which it was recovered. Quote para 12 from the judgment. Under aforesaid circumstances, this court is of considered opinion that from the materials available in the case diary, the twin embargo section 37 of the NDPS Act will not be applicable to the petitioner at this stage. The court paragraph 14. He will appear within 7 days and 50,000 with full surety.
Much obliged.
Code para 14, 15, 16.
Highly obliged.
Standing item 22.
But the order is at page 25. But initially, prayer was made at page 22. On 11, production warrant was issued on 17,
Where is the prayer?
22. Page 22 is page 23 under the above circumstances. I subject this lordship prayer to issue production warrant against the accused person and shown arrest with a prayer for police custody of 6 days. Now, lordship, prayer at
Page 23, where are you reading?
22, lordship.
Is it 22 and 20 or 23? You have to.
22, it starts, lordship. 23 is the prayer. Under under the above facts, last paragraph, lordship. Facts and circumstances, I pray your honor kindly to issue production warrant of the following accused person in connection with the instant case and remand him to police custody of 6 days. Yeah.
There is no specific prayer for showing arrest.
So in subject at page 22, in subject portion, reference is this case.
Okay, showing him arrest.
Hereafter at page 24. 20 and 25, lordship, now custody warrant is issued.
Now, what is your submission?
Lordship, firstly, before, though in the earlier case, the grounds of arrest was given. In this case, lordship, which is shown arrest, no grounds of arrest is given, firstly. Secondly, lordship.
Whether in case of shown arrest, it is required.
It is required, lordship.
You have authority.
Yeah, yes. para 10, Lordship.
Okay. Okay, then what is the submission?
Thereafter, Lordship, 25A would not be attracted because of
Well, arm's length.
45D.
I'm saying.
Lordship, at page 22, the seizure is given.
Yes.
Page 22, the seizure is given. 4 pieces of empty cartridge of suspected 9mm caliber pistol, 1 empty cartridge is suspected to be 7.62, 2 live ammunition of suspected so-and-so. That is the seizure, Lordship. Now 45D, act not to apply in certain cases. 45D, Lordship. Page number 27 of the arm. Moreover, length of detention also, Lordship.
Yes. 45D.
For 45D, X shall not apply, notwithstanding this X shall apply to the accusation, possession, or carrying by a person of minor parts of arms and ammunition which are not intended to be used along with the complementary parts acquired or possessed by that or any other person. No arms has been seized, Lordship, and it is empty cartridge. Only 2 live ammunitions were there. Lordship, my submission is that it the definition of ammunition is also there.
Yes. Where?
Yes, Lordship. Definition in the definition section. Ammunition means ammunition for firearms and includes parts of. Therefore, empty cartridge or live
Empty cartridges are not, but live ammunitions were also found.
live ammunition, Lordship, live ammunition, 2 live ammunition are found, but it will not be included in definition, in this definition because it independently cannot, it is independent, it is not an arm. It's a complementary part, therefore, only that live ammunition cannot be used independently, Lordship. That is my submission.
Okay.
Moreover, Lordship, length of detention also. Lordship, if Lordship counts it up from 18.6 also, it is 49 days. From 11.6 it's 55.
First, I want to state here, Lordship, section 25, that 1A, it is the punishment. And here it is stated that whoever acquires, has in his possession or carries any prohibited arms, there is or prohibited ammunitions, in contravention of section 7. In section 7, which is the substantive section, Lordship, it clearly stated that no person shall acquire, have in his possession or carry, or uses, sale, transfer, expose, so and so, any prohibited arms or prohibited ammunition. So it is well covered under this section, Lordship. Moreover, not only ammunitions are there, Lordship. There are other things are also there. One bank stamp in which text on the stamps, which includes Bank of India and Dispur branch. And in the PD, if I look into it, Lordship, Dispur branch and clarify that he is not an employee. And moreover, another thing is there, Lordship. he personified in the production listed, production warrant, it is also there. He personified and become journalists, sometimes as bank workers and sometimes as businessmen, Lordship. As if I look into the CD, Lordship, it has clarified that in the dispute branch, though he have a stamp, Lordship, he has not been employed. And from the news channel, one prayer is also made to clarify on 94, under section 94 BNS is there, Lordship, to clarify whether he is an employee or not. And moreover, on the ground of production warrant, Lordship, KC Reddy case is there, para 36 is there, Lordship, which Lordship is well aware of.
What is there? In KC Reddy's case,
Lordship, KC Reddy case.
what is provided? What it says?
In para 36, if a person is arrested on a warrant, the grounds
No,
of,
he has not been arrested on warrant.
on shown arrest, Lordship, that is a production warrant.
Production warrant was allowed afterwards.
Lordship, on the date,
This is pending investigation.
Lordship, pending investigation, and he has been on that he has been in living relationship for 4 years, and after that he is thinking that, Lordship, on giving a
No,
frame.
when the matter is under investigation,
Lordship,
first he has to be shown as arrested,
Lordship,
and thereafter production warrant has to be. It is not pending trial. In trial, there is charge sheet is there before the court. Here there is no. If we assume that issuance of production warrant, before issuance of production warrant, he has been shown as arrested,
Lordship,
then he gets a right to know about the grounds of arrest.
Lordship, it is on 17/6, Lordship. On 17/6, page 24. What in, may I read, Lordship? Sir, put up today on the strength of the prayer made by the IO, praying for shown arrest, Lordship. Praying for shown arrest of the accused person, namely so and
Which was
so.
allowed.
It was allowed, Lordship.
Then
First, this was order is made, then Lordship, on fixing 18/6/2025 for production of the accused before the court, Lordship. Then this thing happened, Lordship.
then
Firstly,
when
was
he
shown
was
arrest.
produced,
Produced on 17/6, Lordship, was shown arrest.
okay, then when he was produced,
And 25, Lordship, 18/6. Then it was rejected and he was sent to the judicial.
he was
custody.
produced on 18/6.
Lordship, before that 17/6.
No.
Shown arrest, 17/6 is shown arrest
On arrest.
and 18/6 is there, Lordship.
Then whether grounds of arrest were known to him.
Lordship, definitely, it is there in the 18/6, Lordship. If you look into it, Lordship, it is also there in the petition also, Lordship.
No, no, that is for the first case, 499.
No, it is clearly stated here, Lordship. It is on 45503 in 17,
No,
Lordship.
no.
Lordship may look into it, 17.
No.
Page 24.
Which paper you are referring to? Which
Lordship, from the petition,
petition?
petitioners, Lordship, petition, page number 24.
Yes.
Page number 24, 17/6, Lordship.
The prayer for shown arrest was allowed.
Lordship, in regard to 503, Lordship.
Yes,
This
thereafter,
present case, thereafter, Lordship, 18/6
he was produced.
was produced, Lordship. And
Then
on the strength of production warrant,
production
Lordship,
warrant, he was produced.
produced.
Then whether grounds of arrest were made known to him.
Yes, Lordship.
Where?
And, in my schedule, Lordship. Yes, grounds of shown arrest is there, Lordship.
No, whether,
On 16/6, Lordship.
whether notice was given to him. Whether he was communicated those grounds.
That is in the 18/6, Lordship, considering the prima facie materials appearing upon such perusal, the accused so and so is shown arrested in case so and so of BNS so
No,
and so.
those grounds were made known to the court only. Whether it was communicated to the arrestee. No.
It is not there, Lordship. But as it is before the court, Lordship, and court has already looked into everything, Lordship.
No. Heard Mr. B.P. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sahil Khan alias Sahil Khan Hajorika, who has been detained behind the bar, who is detained behind the bars since 11/6/2025. Since in 503, when you are detained,
503, Lordship, custody warrant is issued on 18/6/2025. Otherwise, cases registered on 11/6.
and the prayer for shown arrest was made on
11/6, prayer for shown arrest 11/6, page 22, Lordship.
when it was allowed,
It was allowed on page 24, production warrant
17/6.
was issued on and page 18, page 25, 18/6.
Not 11/6. Since 17/6/2025, in connection with this 4PS case number 503/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/319 within bracket 2/336 within bracket 3 of BNS, read with section 25 within bracket 1/A of the Arms Act. The gist of accusation in this case is that on, where is the FIR?
FIR at page 16. Lordship.
On 11/6/2025, one Anjan Sharma had lodged an FIR before the officer in charge of Dispur police station, inter alia, alleging that one Krishna Devi Brahma had lodged a complaint before the officer in charge of Dispur police station, on the basis of which a case, that is Dispur PS case number 499/2025 was registered. It is alleged in the FIR that during investigation of the said case, the house of the present petitioner was searched, and during search operation, 4 pieces of empty cartridges suspected to be of 9 mm caliber pistol and 1 empty cartridge suspected to be of 7.62 mm caliber SLR and 2 live ammunition of suspected to be 9 mm caliber pistol and some other incriminating materials were found from his possession. Learned counsel for the petitioner has submitted that before the petitioner has submitted that the petitioner was arrested in connection with dispute PS case number 499/2025 on in 499 when you were arrested
On 10/6.
on 10/6/2025. And while he was in custody, the present FIR was lodged. And the investigating officer of the present case filed an application before the learned before which court? CJM or SDJM? Before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, for showing the present petitioner as arrested in dispute PS case number 503/2025, and also prayed for his production in the said case, which was allowed. Stop. Learned counsel for the petitioner has submitted that though after being shown arrest in dispute PS case number 503/2025, he was produced before the court on, instead of Chief Judicial Magistrate, Special Judicial Magistrate. Before the Court of Learned Special Judicial Magistrate on 18/6/2025. However, no grounds of arrest of the petitioner in connection with the present case, that is 503/2025, was communicated to him at the time of his arrest. Learned counsel for the petitioner submits that though in the earlier case, that is dispute PS case number 499/2025, grounds of arrest were communicated to him, however, in the instant case, no such communication of grounds of arrest has been made. And therefore, he submits that the fundamental rights of the petitioner guaranteed under Article 22(1) of the Constitution of India, as well as statutory right guaranteed under Section 47 of the BNSS has been violated in this case. Which case you are relying?
It's a case of this High Court Lordship.
Learned counsel, learned counsel for the petitioner has cited a ruling of a coordinate bench of this court in the case of Habib Ahmed versus State of Assam, within bracket, bail application number 1096/2025, dated, on which date it was 1096 bracket close, wherein it was observed by the petitioner that where is that observation?
There are 10 Lordship. The case of Bihan Kumar and
Where is it was observed that even in case of shown arrest, the requirement of furnishing grounds of arrest is there, and non-furnishing of such grounds would be violative of his constitutional right, his fundamental rights guaranteed to him under Article 22(1) of the Constitution of India. Learned counsel for the petitioner has also submitted that since, stop, we'll continue at 2. Yeah, I go like go for some time, take this dictation, then change over code. After taking this dictation, change over code. We'll continue at 2. Tomorrow morning, we could not go through the case diary. It will be delivered tomorrow at 10.
Item 22.
22 key asililla. Okay. Has also submitted that since in this case only emanations have been recovered, no offense under section 25 within bracket 1A has been made out in this case as where is the arms act? Arms act. Arms act is in as under as the exceptions provided under article under section 45 within bracket B of the Arms Act would be applicable to this case. He also submits that otherwise also the petitioner has been detained behind the bars for last 49 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of case diary is there.
Dispute PS case 503.
Dispute PS case 503/2025 and has objected to grant of bail to the petitioner. Stop. He also submits that there are sufficient incriminating materials in the case diary and the investigation is still going on, and the release of the petitioner at this stage may hamper the investigation. He also submits that since the production of the petitioner in connection with this full PS case number 503/2025 has been done in pursuant to a judicial order passed by a competent court, no requirement of furnishing any notice under section 47 in such case would be, is there. And therefore, he submits that there has been no violation of any fundamental rights of the petitioner in this case. I have considered the submissions made by learned counsel for both sides and have gone through the case diary, which is produced by, which is before the court. though learned counsel for the petitioner has pressed for bail on different grounds. However, let us first examine the ground that no grounds of arrest were communicated to him when he was shown arrested in connection with dispute PS case number 503/2023. So it appears that before showing him arrest in the aforesaid case, that is dispute PS case number 503/2025, the petitioner was detained in judicial custody in connection with dispute PS case number 499/2025. It also appears that though by order dated 16 where is the order dated 17
It's 24, 76.
17/6/2025 passed in dispute PS case number 503/2025. Learned special judicial magistrate had allowed the prayer of the investigating officer to show the present petitioner as arrested in the said case, and in pursuant to the production warrant issued by the said court, he was also produced before the said court on 18/6/2025. However, there is no material on record to indicate that the petitioner was communicated with the grounds of his arrest in connection with this food PS case number 503/2025. This court has observed in several of its earlier rulings including the ruling cited by the learned counsel for the petitioner in the case of Habib Ahmed versus State of Assam Supra, that the constitutional requirement of communicating grounds of arrest to an arrestee is not waived in case where the petitioner is shown arrest while he was already in custody. Stop. Even in a case where where a person has been shown arrest in a different case, he is entitled to know about the grounds of his arrest. His fundamental rights guaranteed under Article 22 within bracket 1 of the Constitution of India regarding communication of grounds of arrest would also be there in case of a shown arrest case. Stop. And any violation of stop. When a person is allowed to be found arrested in some other case by a judicial order, it is the duty of the arresting authority to communicate the grounds of arrest in writing to him. Stop. If same is not done, it would be infringement of his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India. Stop. Such an infringement would vitiate the arrest itself, and on that count, such an arrestee would be entitled to get bail. As in the instant case, it is apparent that no grounds of arrest were communicated to the petitioner, comma, in writing, comma, in connection with this full PS case number 503/2025. His fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India has been violated. And therefore, this court is of considered opinion that he is entitled to get bail on that count itself. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judicial Magistrate, Kamrup Metro, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
No grounds of arrest is there. Can go to call for law. Can go to. Okay. Online happen.
Your notice was served on you.
So already LCR is clear.
Whether notice was given to you or not.
Lordship. In case number 40, Lordship, 40 and 41.
Yes, Mr. Any other ground?
No, Lordship, only this.
Yes, Mr. Das.
We have not control, Lordship. Just now it has taken. Can copy law. It does not come.
Go through it. We'll take it up. After 1 hour. Let him go through the scan copy.
16 also same, Lordship.
Okay. 16, 17.
So order item 32.
Mission আছে, না? Yes, you are not there.
Item 32.
None has appeared. For the appellant on call. Mr. K.K. Das, learned additional public prosecutor, is representing the state, is present. Let this case be listed on after a week on a date to be fixed by registry.
33,
May I please proceed? Madam, this is criminal LPA 15 of 2009 for filing under section 4 of the section 378 of the criminal procedure code for granting special leave for filing appeal matter against the impugned judgment dated 5/5/2014 passed in criminal appeal number 19 of 2014.
Notice has gone.
It is already noticed, sir, my lord, and the name of the learned counsel for the respondent number 1 is shown in the causes, my lord, and they file lookout number also. As per office note dated 27/10/2021, advocate have initiated appearance on behalf of the respondent number 1, my lord, by filing lookout number. Their name is shown in the causes also, but they have not appeared.
Who is the counsel?
So, my lord, Devashish should be should.
What is to be done?
Further notice. They have received the notice. That's what the counsel
No,
has,
Mr. Disur is coming to the court or not?
my lord.
You know him.
I know him, but I don't have his phone number, my lord. I could today, yesterday also, I searched how to contact with him.
Yes, yes, Sabu, phone number আছে নিবে। Wakalat number. We will find out. We'll list it again next week. Heard Miss U Chakravarti, learned senior standing counsel,
Counsel.
senior railway counsel, appearing for respondent number,
Excellent, my lord.
appearing for the applicant / appellant. Yeah, Mr. Miss M Chakravarti, not me. M Chatterjee. No one has appeared for the, no. Also heard Mr. K. Das, learned
State judge.
additional public prosecutor, appearing for the state respondent.
The state of Assam is the performer respondent.
Who is respondent number 1 and 2?
One is the Utpal Saikia and 2 is the state of Assam.
Okay. Though it appears from the records that name of Mr. D. Sur has been shown as engaged counsel for respondent number 1. However, he was not found on call. Considering the above facts, this court intends to give one more chance to the respondent number 1, and hence let this case be listed on 21 August.
34, item number 34,
None has appeared for the appellant on call. Let this matter be listed. Date attorney. 21 August.
item 35,
Please, your lordship. Text of the case is there.
Why it has come in orders column today?
Petitioner number 1, Mohammed Salim and his family members
his wife, his two children, entered into India without a valid passport, madam. Therefore, they were arrested and conviction also. uh, i- i- There was a conviction for 3 months, my lord, and that period of conviction period is already expired on my lord, 7/9/2012, my lord. And hereafter, my lord, about more than 12 years, they have been retaining in detention camps, custody. My lord. Therefore, the petitioners are seeking for deportation, immediate deportation. They have been seeking.
May it please your lordship. The case was last listed on 6/1/2025, lordship, and we have the instruction of on February 10, 2025. So we don't have the latest instruction, but according to February's instruction, is written a response from the Bangladesh side on verification of their nationality is awaited. Repatriation process will take place only their nationality is verified and travel documents are issued by the receiving state also. So we need a latest instruction so that short date may be given, lordship.
How many dates are taken only?
They are behind the bars for 12 years after serving all these things.
But lordship, Bangladesh side is not responding, lordship.
No, they will never respond. Then what is to be done in such cases? You come up with submission on that count also. If they don't respond,
Yes.
whether they, what is to be done? Had Mr. What is your name?
A.N. Ahmed.
A.N. Ahmed, learned counsel for the petitioners. Also heard Mr. What is your name?
K. Kolita, lordship,
K. Kolita,
on behalf of K. Parasar.
appearing on behalf of Mr. K. Parashar,
CGC.
learned Central Government Council, appearing for respondent number 1. Learned Council appearing for Union of India has submitted that the Union government has taken up the matter of repatriation of the petitioner to Bangladesh. However, the response from the said state, that is Bangladesh, is that they are yet to verify the nationality of the petitioner. Learned Council appearing for the Union of India has also submitted that the instruction received by the council is of February 2025, and he prays for some time to get the latest instruction in this regard. The prayer is allowed. Let this matter be listed when?
Short date may be given, lordship. Next week. Need it.
Next week at a date. 13th of August.
Item 36.
What is this?
By this petition, I am going for a renewable inquiry. Because I had lost an FIR,
Why it has come up?
so this was not completed.
Now is it
Now-
complete?
Private was not so completed by sir. Others are stable.
In this regard, I have one submission. We are made party as a 7 and it is written as Director General CBI. There is no post as such Director General in CBI. So that itself is.
You tell him what is the post, he will amend his petition.
Director CBI, Director of Prosecution CBI, then branches are different.
In fact, I am aware of that. This has come to me from some other company.
Yes, earlier
Yes.
another
I will-
advocate was there.
I will take the correction.
In that event, nobody is responding to me. Neither Delhi branch nor party branch.
You amend the,
I will amend the cost title.
Moreover, case is charge sheeted and we are
Yes.
facing trial.
So here, I would just like to point out why I am before this honorable court. Charge sheet has been submitted. Now, the main accused has been made a witness. The main accused has been made a witness and a charge sheet has been filed against somebody else. Had no charge sheet been filed, had it been returned in FR, I would have been given a notice, I could have made some submission. Here, the main accused is made a witness in fact.
accused named in the affair.
That is what. Now, the
Whether the person to whom you are referring as main accused, he was named in the affair.
lordship, if I may take your lordship to the FIR.
No, today let us not go into,
Yes.
today we will you make the correction of, then it will come up in,
The accused, not main witness. I am representing the accused.
But you disposed of.
Disposed of, yes, I know.
Disposed of.
heard Mr. R.K.D. Chaudhary, learned counsel for the petitioner. Also heard Mr. Who are appearing?
Uh,
Mr. Bishwas, you are appearing
For
for,
respondent number 8.
who is for one? State,
Wouldn't receive surprise. He is filing this case by the so-called Joydev Das under the pretext of main culprit, who is my son-in-law. This is what happened. Because
no. Who is representing state of Assam?
yes. The affair is of 2013.
Go. Mr. S.C. Bishwas appears for respondent number 8. Miss M. Kumari, learned standing counsel, CBI, appears for respondent numbers 7. Mr.
I'm on behalf of Adjournments for S1 4.
Yes, what is your name?
My name is A. Dekar.
Yes, Mr. A. Deka, who is appearing for Mr. S. Bhattakur, learned counsel for respondent number 4, are present. It appears that all the respondents have appeared in this case.
Oh, you say, submit. Amend.
We will understand.
Stop. Learned counsel for the petitioner submits that due to inadvertence, the respondent number 2, respondent number 7 is with regard to respondent number 7, it is mentioned, stated in the writ petition that it would be represented by Director General. He submits that as there is no Director General in the CBI, he needs to amend the cause title and correct designation of the authority representing the CBI.
The notice to the local.
Yes,
They will acknowledge. Need to,
The notice to them.
with notice to them.
That is after amendment of the petition.
yes. The
Right.
prayer is allowed. The petitioner is allowed to file an amended cause title in this case. He shall do so when? Within a week of. A copy of the amended cause title shall also be served on the respondent sides. List accordingly.
So
Forty-seven.
None has appeared for the petitioner on call. Let this matter be listed after a week on a date to be fixed by registry.
It is a lot. But in this case, we are challenging the FIR under 226 Lord. And in the meantime, my Lord, the prosecution has filed a charge sheet. Lord, we had filed an additional affidavit to bring on record. That is not there. My Lord, I have inquired from the registry, my Lord, some defect have been notified. But I may be permitted to rectify those defects.
Who are you?
But I am the petitioner, my Lord.
No, you are the accused.
Accused. But the offense that takes place, but it's in the domain of blood GST offense. Blood penal offense has been leveled against the petitioner.
But why have you preferred a writ petition instead of?
But I can free for quashing under 226 as well as 482 blood. Because there is a policy, blood. It's regarding blood allegation is of blood betel nut. And blood, they have a policy.
Okay, we will let the additional affidavit
Yes.
come on record.
Permit me to rectify the defect pointed out by the registry. In that, we have already filed that, but because
Some defect has been found.
the phone number of the petitioner has to be mentioned, blood. Inadvertently, that phone number was not mentioned. That's how it was not.
Heard Mr. R. Dubey, learned counsel for the petitioner. Also heard Miss, what is your name? R. Gogoi. Appearing for respondent number 1, 2, 3, and 4. Learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit which is not on record as
We have served also, blood.
as some defect has been found in the same by the registry. He seeks some time to rectify the said defect and also prays for calling of the said affidavit after the rectification by the petitioner. The prayer is allowed. Let this case be listed after a week. In the meanwhile, you may do.
But there is an interim order which is continuing.
The interim order shall continue till next date.
Deeply, blood.
Item 49.
Yes, please, Lordship. As per Lordship office notice, neither edicate nor answered notice has been received back in respondent number 2.
You have taken steps.
Yes, sir.
You take fresh steps. Or if you have postal track consignment. Or you take fresh steps. Heard, Mr. What is your name?
Sir, Islam.
S.A. Islam Learned Counsel for the petitioner. Also heard Mr.
I am appearing on behalf of respondent number one, Alan Dihinga.
L.N.
Dihinga.
Dihingia. You are government counsel
No, my lord, I am appearing on the respondent number one.
appearing for respondent number one. All as well as Miss R. Gogoi appearing for respondent number 3. On perusal of the office note dated 29/7/2025, it appears that neither the AD card nor the unserved notice in respect of respondent number 2 has been received by the registry. The petitioner seeks, learned counsel for the petitioner has prayed for allowing the petitioner to take fresh steps for issuance of notice upon respondent number 2. The prayer is allowed. The steps for issuance of notice upon respondent number 2 shall be taken by the petitioner within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
40.
Yeah, please, your lordship. Lordship, as per the office note dated 4/4/2025, the service report is awaited.
What to do? 4/4?
2025.
We will direct to registry to place the track consignment report, postal track consignment. Heard Miss, what is your name? A.
Lala,
A. Lala, learned counsel for the petitioner. Also heard Miss R. Gogoi for respondent number 1, 2, and 3. The office note dated 4/4/2025 shows that neither the AD card nor unserved notice have been received by the registry in respect of notices sent to respondent number 6 and 7. The registry is directed to place the postal track consignment report of the said notices sent to the said respondent through registered post before this court on the next date fixed. Let this case be listed again on 22nd of August.
Item 41.
Okay, on the last occasion, my lord, respondent one sought time for to whether the service of notice has been completed or not upon respondent number 2, my lord.
Boxer is there.
Yes, my lord.
I have only information that Lordship 11/6/2025 notice has been dispatched
From disperse,
from our office, Lordship,
how?
from our office to the OC, Lordship.
By email.
Not Lordship,
It has to go by email.
okay, Lordship.
Now what is to be done? We will appoint
Lordship, it will be better.
business criminal appeal.
I
No,
make a scale.
criminal appeal. No, you verify from the heard Mr.
Please, I come, my lord.
B. Soikia, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned additional public prosecutor has submitted that though notice to respondent number 2 has been sent for service on the said
11-6.
respondent through on the said respondent through the officer in charge of jurisdictional police station on 11/6/2025. However, no service report has been received till date. Stop. In view of the above submissions, comma, learned additional public prosecutor is requested to get the information regarding fate of notice issued to respondent number 2 from the officer in charge of jurisdictional police station. Telephonically through electronic means, and let this court know about the same on the next date fix. Let this case be listed again on 19.
Well, can it be on 14, my lord? He's behind bar from 5/8/2024, my lord.
14. Okay, 14.
Much obliged. Item 42.
Maybe the 41 days delay in condemnation petition is allowed the appeal against acquittal. In a NIA case, my lord, I accused by my lord.
You are victim.
Yes, sir. I am holder of check, my lord.
Near, oh, NI Act cases. Okay. What is the submission?
41 days delay and they have submitted the medical documentation and everything.
You are not opposing. Okay. Heard Mr. A.M. Bordhuya, learned counsel for the petitioner. Also heard Miss, what is the name? B. Soren, learned counsel for the respondent. This interlocutory application has been filed by the petitioner Anisuz Zaman under section 5 of the Limitation Act 1963, praying for condoning the delay of 41 days in preferring the connected leave is required.
Not required even, my lord. I have 5 minutes for abandoned petition.
For connecting for filing the connected leave application for preferring appeal against acquittal. Learned counsel for the petitioner has submitted that the petitioner was prevented. No, petitioner could not approach this court within the prescribed period of limitation, as he was prevented by genuine cause, as he has, which he has stated in the application for condoning the delay. What was the cause?
My lord, he was ailing, my lord, and we are advised, my lord, page 44, my lord. Certified that, sir.
Stop. Learned counsel for respondent has conceded to the prayer for condoning the delay on the ground of that cause shown by the petitioner appears to be supported by medical documents. Stop. I have considered the submissions made by the counsel for both sides as this court is of considered opinion that the delay in preferring the connected leave petition for filing appeal against acquittal has been sufficiently explained by the petitioner in his application for condoning delay. The said delay is hereby condoned, and this interlocutory application is hereby disposed of. Registry is directed to Dukas. Leave petition has been registered. Why leave is required?
Actually, my lord, recently, my lord, I have gone through one judgment, my lord, leave is not required from the Supreme Court, my lord.
NI case. NI Act cases. This is a check bounce case. Then whether you will fall within the category of victim.
Yeah, is also there.
Answer. Whether you will fall within the category of victim or not. Okay. Disposed of. Registry to leave application you are not opposing.
2 weeks time to be given to get instructions from.
Formal, my lord, appeal, in appeal, they will fight, my lord. It is already, my lord, they condone, my lord.
No, we have to
I can get the instruction.
stop. In leave application, लिखिए this application has been filed under section 419 within bracket 4 of BNSS by the applicant Anisus Jaman seeking leave to file the connected criminal appeal against acquittal of the respondent by the judgment dated. Where is the judgment? Judgment dated 19/7/2025 for passed by Learned Additional Chief Judicial Magistrate Barpeta in NI case number 74/2020, whereby the respondent was acquitted and the NI case was dismissed. Stop. Uporot Likibo heard Mr. A.M. Borguya, same concept. Learned counsel for the petitioner, learned counsel for the respondent has sought some time for filing an objection against the leave application. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Item 43, leave over.
My pleasure, Lordship. Yes, I filed for including of the party, that is the informant of the FIR. Inadvertently in the main AB, the name of the informant was left out as respondent number 2.
Heard, Mr. What is the name?
M. R. Sodial.
M.
R. Sodial.
M. R. Sodial, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public. This interlocutory application has been filed by the petitioner in AB case number 1153 2025, praying for allowing the petitioner to implead the informant, Ms. Halima Khatun, as respondent number 2 in the said anticipatory bail application. The prayer is allowed. The prayer is allowed. The petitioner is directed to submit an amended cause title in anticipatory bail application number 1153 of 2025 by showing the name of Ms. Halima Khatun as respondent number 2 therein. This interlocutory application is accordingly disposed of. Let the anticipatory bail application be listed again on 21/8. Before the said date, the petitioner shall file the amended cause title.
Lordship, in the bail AV notice may go to the respondent number 2 as directed.
No, first you file the amended cause title. Short date. 13th. 13th. You file the amended cause title, then we will issue notice.
Deeply obliged.
Item 44.
May it please your lordship. Lordship, this is an IA for suspension of sentence and grant of bail to the accused person, my lord. He was convicted under the NTPS Act for possession of intermediate quantity of heroin, my lord, and he was sentenced for 5 years of imprisonment. My humble submission, Your Honor, if the Honorable Court peruses the evidence on the record, my lord, there is a very strong chance of acquittal and overturning the sentence of conviction, my lord. So in that,
For how many days you are behind the bar?
I have been behind bar in total for about 6.5 months. 4.5 months after the judgment and 2 months during the period of trial, before the after
And
arrest.
what is the ground?
My lord, the first ground is that, my lord, the section 50 of the NDPS Act was not complied with. I was not informed that I have a right to be searched.
From where the contraband was found?
From my physical possession.
Okay.
That is the allegation. Secondly, my lord.
Section 50 was violated.
My-
And
Then, my lord, the person who conducted the search, my lord, was a police person of a police station not having jurisdiction. It was done by someone from the Bihpuria police station, police outpost, whereas I was Bandedawa police outpost, whereas which falls under the jurisdiction of Bihpuria police station, and whereas the search was conducted in a place under Laluk police station, my lord. He ought to have informed the Laluk police station, and the police officials from Laluk ought to have taken action, my lord. I have also obtained the relevant notification, if your lordship kindly peruses that.
but if it is the trial court records have come, yes, then it can be heard 5 years only. No, what is your submission regarding? Oh. Final hearing of okay, first you give the copy. No, if we don't take up the interlocutory application, then he has to file an application for expeditious hearing. Otherwise, appeals are in queues. Okay, we will consider the matter. Heard Mr. S. Day, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed under section 430 within bracket 1 of BNSS 2023 by the petitioner, namely Abul Hussein, alias Abul Hussein, who praying for suspension of execution of sentence imposed on the petitioner by the judgment dated 23/2025 passed by learned Special Judge Lakhimpur in Special NDPS case number 10/2022. And also for bail during the pendency of the connected criminal appeal number 210/2025, wherein the applicant has impugned the aforesaid judgment. Sublearned additional public prosecutor has submitted that he has not been furnished with the copy of interlocutory application along with annexures. The petitioner is directed to, when you will furnish?
I will furnish it by tomorrow morning.
Is directed to furnish a copy of interlocutory application along with annexure to learned additional public prosecutor within 2 days from the date of this order. Let this case be listed again on pen.
Kindly fix a date in the next week if feasible.
After 15 Lordship.
On 20.
Much obliged.
What is this?
This is application for modification of an order that the conditions put in the bail order, Lordship.
Okay, under what provision we can modify?
Lordship,
Thank you.
it was filed under 483 can be read with 528 of BNSS. Lordship, code events already modified similar order.
No, maybe, but I have a
120.
specific 483 10B. Modification of order passed by which court?
Lordship, this honorable court, Lordship. On condition, Lordship,
It is not 10B, it is 1B, which is not applicable. Yes, Mr. Das.
Yes, Lordship, it is by
You,
Delhi.
you received the copy?
That's why I received a copy.
Yes. What is the submission?
Lordship, the petitioner was arrested in connection with Lordship, Dibrugad PS case number 936 oblique 2016 Lordship. Under section 12 and 13 of the PCF, read with Lordship 109, 120B, 420, 465 and 468, 471 and 201 of IPC Lordship. Lordship, in the meantime, Lordship, the petitioner, he has taken, he had got a degree of LLB Lordship. Thereafter, he has been practicing before this honorable court, Lordship. Lordship, as because he is practicing Lordship, he has to go, he has to visit the other course, Lordship, other district as well as the other honorables, other benches of this honorable court, Lordship, at Itanagar and Lordship, therefore, Lordship, he seeks this modification of this point number 3, Lordship, the condition number 3, Lordship, at page 20, Lordship.
No, investigation is complete.
Yes, investigation complete, the trial is going on, Lordship.
So you take a order from the trial court.
Lordship, in a the coordinate bench also grant similar order, cancel those Lordship conditions. The coordinate bench I have already annexed it, Lordship.
No, but of the same petitioner.
Not same petitioner, similar kind of petitioner, Lordship.
No,
They were arrested
what was the ground for cancellation?
Similar ground, Lordship. He
No.
also, that petitioner also became.
Where is that order?
That order is start from 22, Lordship. 23, page number 23, Lordship. Point number 3, para 3, Lordship.
What was the ground on which?
Lordship, similar ground, Lordship, para 3, I am reading from the 1, 2, 3, 4, 5. From 5th para, Lordship. However, as an advocate, the petitioner is facing difficulty in obtaining permission whenever he has to visit other jurisdictional courts. At the same time, his wife runs a clothing business and has a travel to other states. Since she cannot go alone, they also have a minor child. The petitioner.
No, what is the difficulty in taking leave? What is the difficulty in taking leave of this trial court?
No difficulty, Lordship, because
If there is no difficulty, it does not call for any modification.
because Lordship, this bail order granted by this honorable court, Lordship.
No. One of the condition mentions that whenever you want to leave the jurisdiction, you have to take permission of the trial court. What difficulty you are facing in taking permission from the trial court?
Lordship, all the time I have to take permission,
Then what?
then it will be.
You are a lawyer, you are always coming to court. What is the difficulty? I fail to understand.
Because Lordship, my mother also, I have to go outside state, Lordship.
No, there is no bar in not going outside state, but you have to show the difficulty. By merely asking to change a condition, is it sufficient to change the condition which you did not oppose, to which you did not raise any objection when it was imposed? You find out, otherwise it will be not dismissed. You take time and come up with answers.
Lordship, I'll approach the trial court, Lordship.
There is always the bail application, its order itself states that you have to approach the trial court. You are withdrawing this.
This,
Heard Mr. S. Sutradhar. You make submission what you want to do.
Lordship, this matter we fixed on next Monday.
Heard Mr. S. Sutradhar, learned counsel for the petitioner. Also heard Mr. A.K. Das, learned additional public prosecutor. This application under section 528 of BNSS, this interlocutory application under section 528 BNSS has been filed by the petitioner, namely Jatindra Prasad Barua, praying for modification of condition number 3 of the bail order dated 10/10/2018 passed by this court in bail application number 2345/2018, by which the petitioner was allowed to go on bail. When a specific query was posed by this court as to how the said condition has become onerous for the petitioner, learned counsel for the petitioner sought some time to reply to the same. The prayer is allowed. Let this case be listed again. 22.
Obligation. Item 15.
Okay. It is not there.
In item 15, Lordship, 47 I have not found. But in item 16, I have found in Shujit Burman, there is section 50 is there of CRPC.
Okay, let us take item 15 first.
Lordship.
Mr. What is your name?
Yes,
Yes.
yes, and
S. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sorif Islam, who has been detained behind the bars since 14/7/2024 in connection with Special NDPS case number 4/2024 under section 22C of the NDPS Act 1985. Learned, the gist of accusation in this case is that, where is the FIR?
Referring page 12 to 16, Doctor.
That on
Page number 14.
on 13/7/2024, one I.A. Talukdar, SI of police, had lodged an FIR before the officer in charge of Sapor police station, inter alia, alleging that an information was received through reliable sources that one truck bearing registration number AS01RC 8424 would be carrying huge quantity of narcotic drugs. Stop. On receipt of the said information, a search team was constituted and a narco checking was arranged. During narco checking, the aforesaid truck was intercepted and petitioner Sarif Islam was arrested therefrom. During search of the said truck, how much contraband was found?
243 fentanyl cops.
Total 243 numbers of pencil cough syrup containing codeine was recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on the ground of violation of his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India. He submits that at the time of his arrest, though notice under 47 of the BNSS was served on him, however, it does not contain any grounds of arrest therein. No basic facts which necessitated his arrest has been mentioned therein. So, on the other hand, learned additional public prosecutor has correct. On the other hand, learned additional public prosecutor has also submitted that, has fairly submitted
To state here, dear Lordship, I have not found section 47 in the scan copy, Lordship. It is not there,
But in the petition, it is there.
Lordship.
You go through the petition,
But it is there, Lordship, but in the scan copy, Lordship may state them.
whether grounds of arrest are there or not.
In the petition, it is there, Lordship.
Notice is there, grounds are there or
No
not.
notice, or not in this, no, it is not, grounds are not there.
That though notice under section 47 was furnished, was served on the petitioner, it does not contain the basic facts and the accusation and the grounds of arrest and the grounds for which the petitioner has been arrested. So I have considered the submissions made by learned counsel for both sides. The apex court in the case of Vihan Kumar versus State of Haryana and another reported in 2025. 5 SCC 799 has observed as follows. Quote para 26.1 to 26.6. It appears from above that in the event of violation of fundamental rights of the pay of a person guaranteed to him under Article 22 within bracket 1 of the Constitution of India, the arrest of such a person itself becomes illegal, and on that count he is entitled to get bail. So in the instant case also, as the notice which was served on the petitioner at the time of his arrest only mentions the police station case number in which he was arrested and the penal provision involved in the case. It is devoid of basic facts which necessitated his arrest, and as such, the fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India has been violated. And on that count, the petitioner is entitled to get in view of above, the petitioner, above named petitioner is allowed to go on bail of rupees. How much?
50,000.
Rupees 50,000 with one surety of like amount, subject to the satisfaction of the trial court with following conditions. Trial conditions. This bail application is accordingly disposed of.
Appeal.
16 grounds of arrest are there. Not there.
Under CRPC.
At which page notice?
Page number 47 and 48.
It is the same case or different case?
Different case, Lordship. Allegation is like same, Lordship. 192 Fancidal cough syrup has been seized.
Yan gist to Bele Kobo. I'm dictating. Heard Mr. S. Hussain learned counsel for the petitioner. Also Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sujit Burman alias Bittu, who has been detained behind the bars since 23/6/2024 in connection with special case number 534/2024 under section 22C of NDPS Act 1985, which is pending before the Court of Learned Special Judge cum Additional Session Judge Dobrik. The gist of accusation in this case is that on 23/6/2024, Nilim Talukdar had lodged an FIR before the officer in charge of Dhubri Police Station, inter alia, alleging that an information was received through reliable sources that some public has detained one person with 2 bags, which is suspected to contain prohibited drugs. Accordingly, a police team was constituted and reached the spot where the person was detained. The detained person was found to be the present petitioner, and from his possession, how much?
192 pencil cups here.
192 numbers of bottles of cough syrup containing codeine phosphate was recovered. Remaining councillor pura till Beloloke, Angor, as it is, 50,000 millions.
Obligation.
This one, item 7.
May I please?
I am appearing for the respondent number 2, my lord, being the state of West Bengal.
Okay.
My respectful submission, my lord, it is, this writ petition arises out of a criminal case which is pending before the Learned Metropolitan Magistrates Court at Calcutta. It is between 2 private parties in which there is absolutely no cause of action against the state of West Bengal, and state of West Bengal has got nothing to do in it. Unfortunately, the state of West Bengal has been made a party and has been arrayed as respondent number 2 in this matter. There is no cause of action against the state of West Bengal. Even, my lord, the department, the name of the department has not been given by the petitioner. Principal Secretary, State of West Bengal. It has only been mentioned Principal Secretary, State of West Bengal. My lord, I have filed the opposition. And if my lord kindly comes to page 49, running page 49, paragraph 4 and paragraph 5.
No, Mr. Dev.
My lord.
Before you make submission, let the petitioner make his submission.
Lordship.
Counsel for the petitioner.
Lordship.
Your main stand is that you have been wrongly arrayed as party.
I am nowhere in this litigation, my lord.
I'll come to you. Let him make some.
Lordship.
We are in this case, at this stage, the respondent number 1 supposed to file their affidavit, but till date they have not filed.
No, what you are challenging in
Yes,
this
Lord,
case?
so I am challenging is complaint case filed by the present respondent number 1,
Complaint case,
complaint case, Lord.
under what provision?
Under 226(2), Lord.
No. The complaint case is a criminal complaint case.
Yes,
Under what provision?
it has been filed under section registered 406 and 420, Lord.
By respondent number 2.
Respondent number 1, Lord.
Who is representing? 1. Respondent number 1
Yes.
against you.
Yes, Lordship, against petition.
Where?
They filed it at Calcutta, Lordship, before the Metropolitan Magistrate, Lordship.
Kolkata. What is your main plea? That
Is that, Lordship,
lack of jurisdiction.
Yes, one is lack of jurisdiction, second is no criminal case at all not maintainable because it's a loan dispute, Lordship.
No, but why have you filed this writ petition in this court
Yes, Lordship.
instead of court at Calcutta?
Lordship.
Why?
Because this court, this honorable court also has the jurisdiction because the cause of action wholly arose at Assam, Lordship, Karimganj and as well as Guwahati.
No cause of action for this writ petition arose in Assam. We will not go for cause of action for the complaint case. Cause of action for this writ petition is passing of the order by the magistrate at Kolkata.
Yes.
And
This honorable court has the jurisdiction to entertain this petition under 226(2) of the Constitution of India.
what it says.
It says, Lordship, if any cause of action arose wholly or in part even within the jurisdiction of this honorable court, this court can
No,
entertain.
what is the cause of action for a Perry approaching this court?
Because this criminal suit, Lordship. filed-
Criminal cause passed an order. That is the cause
Yes, Lordship,
without jurisdiction.
without jurisdiction. Connected
No,
to jurisdiction of this honorable.
that, your main plea is that a criminal court without jurisdiction passed an order issuing, say, bailable, non-bailable warrant against you.
Yes, so organization is taken and subsequently.
That if that order is within jurisdiction or not, it has to go to the higher court having territorial jurisdiction over that court. It should have gone, the writ petition, if any, should have been filed before the Calcutta High Court.
Calcutta High Court also has the jurisdiction, but this honorable court also has the jurisdiction.
How?
Under Article 226(2), Lordship. Because
No.
my residence is at Karimganj, Lordship. I have taken loan from the Karimganj. The finance institution given loan.
No, that matter is not before us.
Yes,
This High Court is not going into your original complaint.
yes.
This High Court is very fine, is to examine whether the order passed by the magistrate is beyond jurisdiction or not.
But within the jurisdiction, Lordship.
The order
Considering the situation.
order of the magistrate, that the court which passed this query is to all of you, those who are representing the Mr. Dev also.
My lord,
In this case, an order which has been passed by a court at Kolkata has been assailed by filing writ petition. Unless this court has jurisdiction over that court, whether it can exercise writ jurisdiction or not.
my lord, I have raised the issue of territorial jurisdiction also.
Lordship, this question came at the motion stage, Lordship. I think three consecutive days, this matter heard by the.
Whether any reasoning has been given.
No, specific reasoning for admitting this petition, I think not given. Lordship, Mr.
No, this has not yet been admitted. It is in the
I
admission
have placed
stage.
some judgment, Lordship, regarding this query, Lordship. I would like to read the Honorable Apex Court passed a judgment on reporting 2020-10 SCC 7.
You have copy?
Think.
Okay, read.
Yes. This is the relevant portion of it.
paragraph 20. This court has occasion to consider the cause of action in the context of Article 266 of the Constitution has explained the expression cause of action in a large number of cases. We have referred to the previous judgment on this court and ONGC versus Utpal Kumar Basu, where in paragraph 5 and 6 following has been laid down. SCC PP 71617. Cause 1, the Article 226 being with a non-existent clause notwithstanding anything in Article 32 and provides that every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within whose territories direction, order, or writ for the enforcement of any of the rights conferred by Part 3 of the Part 3 or any other purpose. Under Clause 2 of Article 226, the High Court may exercise its power conferred by Clause 1. If the cause of action, wholly or in part, had arisen within the territory over which it exercises jurisdiction, notwithstanding that the seat of the such government or authority or residence of such person
Okay,
is not within whose
Okay.
territory.
that is my query. The law is if the cause of action arises wholly or within the, in part, within the territorial jurisdiction of this High Court, the writ petition is maintainable. But what is the cause of action for this writ petition? Cause of action is an order
Yes.
of a court which is beyond the territorial jurisdiction
Yes.
of this court.
This part also covered in this judgment.
No,
I would like to read the other.
that, okay, please read.
On a plain reading of the aforesaid 2 clause of Article 26 of the Constitution, it becomes clear that a High Court can exercise the power to issue direction, order, or writ for the enforcement of any of the fundamental rights conferred by the Part 3 of the Constitution or for any other purpose, if the cause of action wholly or in part had arisen within the territories in relation to which it exercised jurisdiction, notwithstanding that the seat of the government or authorities or the residence of the person against whom the direction, order, or writ is issued is not within the said territories. In order to confer jurisdiction of the High Court
You read
of
this line
Kolkata.
again.
Yes. Part 3 of the Constitution or any other purpose, if the cause of action wholly or in part had arisen within the territories in relation to which it exercised jurisdiction, notwithstanding that the seat of the government or authorities or the residence of the person against whom the direction or order or writ is issued is not within the said territories.
No, that is okay. But the cause of action should be either in part or wholly within the territorial jurisdiction of this court. If a court below High Court exceeds its jurisdiction, it is for that High Court to rectify that error. Now, we are not considering this subject matter of the complaint. Because complaint is not before us. Before us is the order of the court. My question is whether a order of court at Kolkata may be subjected to the jurisdiction of this court. If so, under what circumstance?
Yes, Lordship, if that triggers this question already go before the Supreme Court and I think 2-3 judgment, Lordship, it has been clear.
Which judgment?
One of this is, and in this judgment also 2 other judgment is quoted. I would like to,
But
in another point also.
this
discuss.
is what I have,
Similar
no,
situation
what
is
I have
already-
understood from you. That is not what Supreme Court is saying.
Yes.
Supreme Court is saying what I have understood from hearing you, that cause of action has to arise either wholly or in part within the territorial jurisdiction of this court. Then if that happens, then the person against whom the writ is issued, if he is beyond the jurisdiction also, writ is maintainable. But first, cause of action should arise within the jurisdiction of this court. And For you approaching this court, the main cause of action is you are alleging that the Kolkata High Court has gone beyond jurisdiction. Now, whether Kolkata court has gone beyond jurisdiction, passed an order beyond, whether it has exceeded its jurisdiction or not, it is for the Calcutta High Court to see. That is my understanding.
Yes, Lordship, Your
You
Lordship,
place some,
yes, but in a similar case, Lordship, I think so far I remember in a Delhi High Court.
no,
Lordship,
remembering will not do. You have to
yes,
show.
I have placed some judgment, Lordship, but I have read one by one. If it is go to the final hearing, definitely I will argue on that point, Lordship. I have the
No,
answer.
if it is not meant, if you fail to satisfy me on the question of maintainability, I will
Yes,
not admit it.
I will satisfy, Lordship, I have the judgment, Lordship.
Yes, ma'am. And why have you made state of West Bengal and state of Assam as party?
Only because of this question, state of Assam I have not made party, Lordship. State of West Bengal I have made party because of this territorial jurisdiction. This question may arise, why you not have made them party? So from safer side, Lordship, I have made them party, state of West Bengal.
No, for safer side, you cannot trouble a person who is not required to be made as party.
Because of this territorial jurisdictional question.
If you drag somebody who is not required to be there in a litigation,
Only
you may
because
have to bear costs.
Only because of this question, territorial jurisdiction question, Lordship.
Then if you have wrongly made him a party, are you ready to bear costs for the inconvenience caused?
No, Lordship, they are the necessary party because of the territorial jurisdiction, Lordship.
Now, what relief you are seeking against him? First of all, you have to satisfy that this court has jurisdiction to entertain such writ application, which you have not yet able to satisfy. Yes, Mr.
I
Dev.
will satisfy, Lordship.
Madam, well, so far as the respondent number
You are
2,
seeking time
Lordship.
because
may I develop?
whatever you have submitted till now, unless you show a exact authority, I am going to dismiss it on the question of maintainability.
Under Lordship, I will satisfy your Lordship.
Yes, Mr. Dev.
Today I have
My lord, leaving aside the part of maintainability, which has been raised by me also in my affidavit in opposition, that the matter lacks.
It is there in record.
Now, so far as Article 226(2) is concerned, my lord, it specifically says that provided that the cause of action for the writ application arises within that jurisdiction.
Yes, yes.
Now, my lord, as far as this issue is concerned, if the petitioner has any grievance, the appropriate forum is the Honorable High Court at Calcutta,
That is my understanding.
because the matter is pending before the Metropolitan Magistrates Court at Calcutta. That is one aspect of the matter, my lord. Secondly, my lord, as far as I am concerned, I am state of West Bengal. I have got nothing to do in this matter. It is purely a dispute between two parties, a financial dispute between two parties, out of which a criminal case was registered on the basis of a criminal complaint. The House state of government, how the state of West Bengal has been arrayed as a party here, where there is no cause of action against the state of West Bengal. There is no allegation against the state of West Bengal. I have nothing to do in the litigation. I have been dragged unnecessarily. And since the month of February, I am appearing in this matter regularly, just trying to highlight this particular issue, that I have been unnecessarily dragged in this particular litigation, since there is no cause of action against me. Even, my lord, your lordship will see that the name of the concerned department, if the petitioner is aggrieved against the state of Bengal, it has to be against a particular department of the state of West Bengal. No name of any particular department has been mentioned. Only Principal Secretary State of West Bengal. What does that mean? There are hundreds of Principal Secretary in various departments.
There may not be hundreds.
At least 40 to 50, my lord.
Still, it is a large number. How many
There are so-
principal secretaries do you have?
My lord, there are 48
Okay,
ministries.
okay,
So it should be 48, my lord.
okay. Okay, yes, other respondents regarding respondent number.
Is not at all maintainable, lordship. 2 to 26 2 is clear, lordship.
How?
Because it clearly specifies that the power conferred by clause 1 to issue directions, orders, or writs to any government, authority, or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Because the criminal petition, that petition is pending before the concerned high court, concerned trial court. And that trial court is under the jurisdiction of Calcutta High Court. So cause of action arising there, and they have filed this writ petition hearing. 226 is clear.
Yes. Other response, Mr. Bhattacharya.
Sir, they have lost.
Okay,
And we have also
You-
filed affidavit also. Lordship.
okay. Affidavit is there.
48.
Yes, you want to show some authority. When?
Fix a date on Monday.
On maintainability of this writ petition. Heard, Mr.
P.A. Chaudhary.
What is your name?
P.A. Chaudhary.
P.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. S. Dev.
Be there.
Sorry,
Vishwajit.
B. Dev, learned senior counsel appearing for.
Respond number 2.
learned
Respondent number
senior
2, State of West
counsel,
Bengal.
assisted by Ms. P. Bhattacharya, learned counsel for respondent number 2. Also heard Mr. P. Bordole, learned counsel for respondent number 1.
State of Assam is also party here, Lordship.
Who is appearing for state of Assam? No one has appeared for. You have to satisfy me on next date. How state of Assam is a necessary party in this case.
Pro forma respondent.
No, for making, you cannot make me a party there. For making pro forma respondent also, you have to show some reason. For making pro forma respondent also, there has to be some reasons. That reason you have to satisfy, apart from the question of maintainability. What is the lastly? A question of maintainability of this writ petition under Article 226 within bracket 2 of the Constitution of India was raised by this court, to which learned counsel for the petitioner submits that he may be granted some time to produce some authorities in support of his submission that this writ petition is maintainable. The time is allowed. Let this case be listed. On 28/2025.
My lord, will it be possible on 19th?
On
I am in
19th.
Guwahati on 19th.
Okay, on 19/8. 19/8.
19th of August.
Yes, 19th of August.
I am obliged, ma'am.
The interim order shall continue till next week.
I am deeply obliged.
9.
May I please, my lord? My lord, this petition filed regarding the Jimma of a mill, my lord.
Jimma,
Mill, my lord. Rice mill, my lord. Rice come.
ये तो what
My lord, earlier in this case, the respondent government, G Assam was appeared, my lord. They also filed a affidavit.
where is government advocate? What is to be done?
Upon your lordship.
We'll list it next week. Mr.
Lordship,
Mr. K. Hassan,
PM, sir.
K.M. Hassan, learned counsel for the petitioner. None has appeared for the state respondent, though the name of this is item number. Though the name of Government Assam, Government Advocate Assam is there in the cause list. PP has to be, PP is also there. Learned additional public prosecutor is present. What is the case?
My lord, one incident took place, my lord, in the male compound, my lord. A boy is at about 13 years, which finger was cut off, forefinger was cut off, my lord. And regarding, my lord, two complaint was, one FIR was lost before the police, my lord, and another complaint lost before the Deputy Commissioner Morigaon, my lord. The Deputy Commissioner then it's forwarded to the Assistant Commissioner, my lord, for the investigation inquiry, my lord. Then he make it inquiry, my lord, and during this inquiry, my lord, he sees the mill compound, seal the mill compound, my lord. That is the case, my lord. We are approached the lower court, my lord, trial court, my lord, for the Zimma, my lord, but a learned court below, my lord, refused.
Then why writ petition criminal has been registered?
My lord, as my lord, the mill compound was seized by the Assistant Commissioner, my lord. Assistant Commissioner.
That was not in connection with any criminal case.
Yes, my lord. There is also criminal case also, said case was substituted, my lord.
But in that case, no seizure was made.
No, my lord. Though IO was paid, my lord, during that, when you are filed the Zimma petition, my lord, that time the IO was paid, submitted petition to for the
Seizure was made in which case?
My lord.
Seizure was made in which case?
What will come to page 26, my lord, page 25, my lord. It is on my lord, Nikki Vita PS case number, it is seized, my lord, as written, my lord.
Page number?
25, my lord. Type 40, my lord.
Okay. Let the government advocate has filed an
Affidavit, they file affidavit.
What is their stand?
They are stand that I falsified some documents, my lord. Their stand is that at that time the mill was not registered, my lord, though it was not correct.
Okay, let him come. Let him.
Yes, my lord. We also filed a reply also jointly.
Okay. As learned government advocate is not available today, this case is adjourned for the day. This adjourned for today. Let it be listed again on
14 may given, my lord.
14,
Any date, my lord. 14 may.
13.
My lord.
Let this case be listed on 13th of.
Obliged, my lord.
This is for pursuant of a complaint, Lordship. The complaint being civil in nature. My brother is entered appearance.
Yes, my lord. I'm appearing for the respondent, my lord. So before argue my learned senior and my lord, the annexers
running from, starts from 32.
These are their documents, Lordship. I am helpless.
So my
They have
lord-
filed their documents in that manner
and
in the
I will
court.
go
below.
to my lord.
Let him say what you intend to say.
My lord, I need some time, my lord, to prepare the case. So lordship kindly give some time to prepare.
No, you are showing some documents.
Yes, my lord, that documents, the terms and conditions that they have annexed, my lord. In page number, running page 31, my lord.
Yes.
That copies are not legible, my lord.
These are their documents, Lordship. I am helpless.
We have not annexed that document. my lord.
Yes, they have. This is the certified copy I have brought. Lordship can kindly have a look. And upon this document, cognizance has been taken.
কি কইছা?
Certified copy I have obtained, Lordship.
কি কইছা? 50, 51. My lord, 50 and 51, my lord.
Okay, now what is your prayer? You need some time.
Yes, my lord.
50-51 we will provide if required. We have got a
50 and
copy.
51, my lord.
We will provide that.
Time for what? Filing objection. You will file written objection. Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr.
Yes,
What-
Sharma, my lord.
What is the name?
Yes, Sharma.
S. Sharma. Learned counsel appearing for the respondent, who submits that as some of the documents annexed along with the criminal petitions are not legible. He needs some more time for preparation of a written objection against the prayer of the petitioner. The prayer is allowed. When
We'll give them the copy today itself, Lordship.
the
50 and 51 pages.
This is the matter after 2 weeks, my lord.
the learned counsel for the petitioner undertakes to furnish the legible copy of the documents to the
Page number may kindly be mentioned. Lordship.
legible copy of the documents
51 they are saying.
mentioned in
50,
at page 50
51.
to the petitioner.
Intent kindly continue, Lordship.
Stop. Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next day.
Diplo.
Obliged.
Item 11.
Well, a petitioner, petitioner lordship, my lord, is actually the decision of the, my lord, and it settles the, my lord. Yes, 42, my lord. Whereby the
We are taking up a interlocutory application first. Thereafter you are ready for hearing
it's coming for the first time, my lord. So,
or for admission only?
Yes, my lord.
Okay, we'll admit it.
Yes,
Heard Mr.
yes, sir.
S. Hawk, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This appeal under section 415 of BNSS 2023 has been filed by the petitioner, namely Barek Ali, who has impugned the judgment and order dated 16/5/2025 passed by learned Sessions Judge Sirang in criminal appeal number 17/2025, whereby it upheld the judgment dated 28/2/2025 passed by learned Chief Judicial Magistrate Sirang in PRC case number 56/2024. So, in the said PRC case, the appellant was convicted under section
279.
279 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 6 months, as well as 6 months stop. He was also convicted under section 304A of the Indian Penal Code and was sentenced to undergo
Yes.
simple imprisonment for 2 years and to pay a fine of rupees 2,000. Stop. In default stipulation is not there. In default of payment, that was not there. You have verified.
Judgment is there. Page 36. Suffer simply for yes, default is there. Sorry. Page 36.
You have not mentioned.
Right.
In default and in default to undergo further imprisonment for 20 days.
Right.
Stop. This appeal is admitted. Let the records of criminal appeal case number 17/2025 as well as the records of PRC case number 56/2024 be called for from the concerned courts. Also issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by registered post with AD as well as by usual mode within a period of 7 days from the date of this order, returnable after 4 weeks. Since learned additional public prosecutor has appeared, no formal notice need to be issued to him. List accordingly.
I'm objecting.
Production, please item 1.
Wait, did you know?
No. NCB is there.
We have informed them, we have submitted extra copy also. I have informed Meenakshi, the junior counsel. She stated that she's in all High Court building. She'll be coming.
When she will be coming.
This
She
is the
has-
problem, also.
We'll wait for her. We'll take some other item. You inform her.
We have already informed.
We'll take next item. Let her come.
May I please, Your Lordship?
Production list are wasn't.
Lordship, during trial, based on a school living certificate, claim of juvenility was, juvenility of the petitioner was claimed before the trial court, but it was rejected. By impugning that rejection order, we prefer this criminal petition, Lordship. Before coming to that.
The informant is
Yeah.
represented. Yes.
And the petitioner is behind the bar with effect from 3/1/2025, my lord. As on today, 215 days he behind the bar. Lord, before coming to the lordship, may I examine the FIR, page 29, my lord.
No, FIR, okay.
My lord.
Yes, what is it?
Page 29, my lord.
Yes.
With due respect, may I state that on 5/7/2018 at about 4 p.m. I went to market. My lord, informant is father of the victim. At that time, my daughter, namely Miss Mamani Begum, 12, was alone at home. At about 5 p.m., after cleaning the courtyard with the broom, she entered into her house, and by keeping her dupatta on alna while she wanted to come out from house, therefore said accused number 1 with pre-planned manner, court held her so as he was waited for opportunity by hiding himself behind the door of the house and by pulling down on bed, appeared upon her body and tried to commit rape. With a view to save herself, the victim, her girl, while tried to raise hue and cry, the accused person gagged her mouth with a pajama and again tried to commit rape upon her. In the meantime, the accused number 2, who was keeping watch from outside, gave a signal that my wife is coming, and then both were run away. Well, this is the allegation.
Who are you?
Well, accused number 1, my lord. Accused number 1 here is Hurmuzen. My lord, matter was investigated, matter was charge sheeted, and co-accused was already is acquitted after trial. But during trial, my lord, petitioner, he was received summon. Accordingly, he approached the honorable court for anticipatory bail. It was rejected. Then he surrendered before the court. Since then, he is behind the bar. So, Lordship, trial is going against this present petitioner. Now, my lord, kindly turn to page 84, Lordship.
Page number?
84, my lord.
Yes. Yes.
Seer put up today, accused has voluntarily appeared before this court, heard learned counsel for both sides, perused the seer, and it transpired that the co-accused has already faced the trial and was finally acquitted in this case. The present accused was absconding and evading the process of trial. Heard the accused person, he has stated that he has no any other health issues and external injuries. He has also stated that he has engaged lawyer. So, see, from this date, he is behind the bar, with effect from 3/1/2025. Now, kindly turn to page, page 96, the impugn order. 96.
Yes.
Accused Hurmuzel is produced from jail Hazur through VC and he is represented by his learned counsel. The school headmaster of number 1 Jharkhand Haji Subha LP school is present and he is examined along with the school register. As per his version, he has issued the school leaving certificate by putting the date of birth as on 29/8/2002. On mere oral version of his parents, there was no date of birth certificate produced by his parents at the time of taking admission in the school. Further, I have also noted that on the date of occurrence of the offense was on 5/7/2018 and he obtained the school leaving certificate on 22/1/2019. On belated obtaining of the said certificate shows otherwise to take advantage of juvenility in the legal parlance, but there is no credible data information regarding exact date of birth of the accused. I have also observed the accused and form an opinion that he was measured in age at the time of commission of offense. Considering thus, the petition so and so hold accused is rejected. So we are trying to raise this issue before this honorable court that procedure has not been followed in this case for determination of the age. School certificate is before the trial court. It is rejected without considering the procedure as per the Juvenile Act. So
what should have been?
Yes, ma'am. Section 94 is there, Juvenile Act 2015.
Now, what should have been done by the trial court?
If there is any if trial court unable to take any conclusion regarding age determination, then they have to follow the lordship. Then I have to follow the ossification test. So without having any other option before the trial court, form the opinion. So it is perverse as per the statutory provision. So we are praying before this honorable court that until and unless determine the age, proceeding may be stayed and he is behind the bar, he may be allowed to remain on bail. 94 subsection 2 is there, my lord. Subsection 2, clause 1. Here is mentioned. I'm reading, my lord.
Yes.
Clause 1, the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board, if available, and in the absence of thereof, the birth certificate given by a corporation or a municipal authority or a panchayat, and only in the absence of one and two above, age shall be determined by an ossification test or any other latest medical age determination test conducted on the orders of the committee or the board, provided such age determination test conducted on the order of the committee or the board shall be completed within 50 days from the date of such order. So in this regard, my Honorable Apex Court also held that if trial court lordship unable to reach any logical conclusion, then the ossification test should be conducted. If Honorable Court will permit me, I'd like to place two judgments. My lord, I am referring the para 18, my lord. Paragraph 18 of the judgment. In case the trial court is unable to reach to a logical conclusion based on the documents, certificates placed on record during the course of the inquiry, it may as a last resort get conducted the ossification test of the paragraph 18, my lord. 1A, lordship.
Yes.
In case the trial court is unable to reach to a logical conclusion based on the documents, certificates placed on record during the course of the inquiry, it may, as a last resort, get conducted the ossification test of the appellant, keeping in view the observations made by this court in the case of Binod Katara. Binod Katara judgment also we have, but here quoted also, my lord, paragraph 13, my lord. 13 is the only Binod Katara.
Read it.
Judgment is quoted, my lord. Paragraph 13, here is that, my lord, ideally, there should not be any dispute to the age of a person if the birth is registered in accordance with law and date of birth is entered in the school records on the basis of genuine record of birth. However, in India, the factors like poverty, illiteracy, ignorance, indifference, and inadequacy of the system often lead to there being no documentary proof of a person's age. Therefore, in those cases where the plea of juvenility is raised at a belated stage, often certain medical tests are resorted to for age determination in absence of the documents enumerated in section 94 of the Act 2015. The rule allowing plea of juvenility to be raised at a considerably belated stage has its rationale in the contemporary child rights jurisprudence, which requires the stakeholders to act in the best interest of the child. So, law is settled in this regard.
No, in this case, an inquiry was conducted.
Conducted, lordship.
The headmaster came, whether
Yeah.
his statement was recorded.
Yes, his statement is recorded that it was not based on the birth certificate. Oral, mere oral version, taking into consideration oral version, this date of birth was mentioned in the school certificate. So it is disputed. Not conclusion is not logical. It should be other options should be there before the trial court. Ossification test also, if there, then it was logical that there is some dispute is there. Prima facie,
When the offense was committed,
lordship, it was 5/7.
now he is a major.
Now he is major.
Ossification test will reveal that he is major.
At this instance, he is major, lordship. Here is 5/7/2018, it was occurred. And if his date of birth is calculated, then his age was 15 years, 10 months, 6 days at the date of occurrence. And the plea of juvenility necessary to calculate
on the basis, on the date of occurrence. So prima facie issue is there. So for it is logical determination, ossification test is there. Should be.
No ossification test in the year 2025, what it would reveal.
Until and unless, yes, dead judgments also there. Until and unless crossing the age of 30, ossification test can be conducted.
Sure.
Judgment is there, Lordship. Para Lordship 39.
Yes.
Paragraph 39, bottom line, I am reading. The courts in India have accepted the fact that after the age of 30 years, the ossification test cannot be relied upon for age determination. This is the last paragraph is there. It is tried that the standard of proof of the determination of this degree of probability and not proof beyond reasonable. Similar, still the burden is upon the prosecution.
No, if you take the plea of juvenility,
My lord.
it is your burden to prove.
Primarily, we have shifted our burden. The certificate is before the line of trial court.
But in inquiry, it was not found.
Inquiry is
You are challenging the,
that is thrown out without considering the ossification test, Lordship.
okay.
How trial court can form opinion without last stage of the determination? It's perverse, Lordship. Subject to the correction, Lordship.
Yes. Yes, miss.
Focus already.
Anything else?
Lordship, unless. And my school register also before.
Their basic contention is that when it was found that school certificate cannot be relied upon, the trial judge ought to have gone for ossification test, which was not done.
It is not that Lordship first ossification test has to be done. First, Lordship, the date of birth of certificate from the school. And in absence of that, Lordship, then the birth certificate given by corporation. And in that absence, then only, Lordship, the ossification test has to be done. Moreover, in section 15 of JJB Act is also there, Lordship. There is an assessment is done. As per section 15 of JJB, Lordship, outlines the process of preliminary assessment for children 16 to 18 years.
No, that preliminary assessment is different.
Lordship.
That is regarding the
Moreover,
capability of understanding.
Lordship. Moreover, in this thing, Lordship, here it was issued on 22/1/2019. And date of occurrence is, Lordship, 5/7/2018.
Yes.
After the occurrence has took place, how it can be, authenticity can be, genuine can be ascertained, Lordship.
His plea is that the accused has taken plea of juvenility.
Lordship.
An inquiry was conducted.
Lordship.
In that inquiry, the birth certificate, the school certificate was produced. If the court does not find it to be reliable,
Lordship.
he is submitting that court should have gone to the next available
Yes.
recourse, that is subjecting the accused to ossification test before arriving at a conclusion. That is, they, on that ground he is challenging.
Yes.
This is,
Lordship.
But there is no credible information regarding date of birth is there, Lordship, as submitted by the accused. Date of birth, it is his burden, Lordship, to prove the, to provide the birth certificate, Lordship. He also, it is from the order, Lordship, it is stated that, but there is no credible data information regarding exact date of birth of the accused, Lordship, is there.
okay. Yes,
He has not provided, Lordship.
Mr. Gogoi. Yes, anything Mr. Sharma wants to add? You can assist.
He is now of 25 years or more, Lordship, then ossification test will also not yield any result, Lordship, as per the
No,
Supreme.
that was my query.
That
But
was-
she showed a judgment which says that up to 30 years, the ossification test can be relied
Yeah.
upon.
Supreme Court judgment, Lordship, regarding that aspect also, Lordship, that it is not reliable. If
No, it
when-
may not be absolute.
Yes, but Lordship, of whole purpose of the section 94 is, Lordship, if the court has some doubt. I know that Lordship, the court has to have doubt, Lordship, it cannot be a mechanical thing, Lordship,
Yes,
that doubt has to be there.
yes.
In this order, Lordship, the learned court below has expressed, Lordship, that regarding the doubt also, Lordship, there is no doubt as such. I have also observed that the accused and formed an opinion that he was major in age at the time of commission of offense.
Now, when the court has observed,
That is reflected in the order itself, Lordship. 11(6).
that would be during inquiry only.
Yes,
That observation will be,
yes.
inquiry was done in the year when it was done. 2025.
Yes.
So,
That opinion, Lordship, that observation regarding on belated obtaining of the said certificate shows otherwise to take advantage of juvenility in the legal parlance, but there is no credible data information regarding exact date of birth of the accused. I have also observed the accused and formed an opinion that he was major in age at the time of commission of offense. This takes care of the doubt part, Lordship. Lordship, the language that has been expressed in section 94, Lordship, it lays some power in the court below, Lordship, to express doubt, Lordship. If there is a doubt, Lordship, only then the other things come into picture, Lordship. That is my humble understanding, Lordship.
okay.
For 94(2), Lordship, the word is strong enough, Lordship. The doubt has to be there. And here, Lordship, the learned court below has formed an opinion in that behalf also, Lordship. So it takes care of 94(2) also, Lordship. And they have produced this document, Lordship. And it is not tenable in the eyes of law as per the observation made by the court below now, Lordship. Now he cannot, Lordship, ask for further. So that is our submission, Lordship. And regarding that also, Lordship, I have forgotten the citation, Lordship, but it was, Lordship, Vinod Katara, 2024 versus State of UP, where, Lordship, it has been held that ossificate and test in regard to 25 years or above may not be, Lordship, reliable.
Okay.
That is considered to be one of the that is also missing.
Yes, Mr. Gogoi, you want to say anything? Whatever, okay. Heard. The scan copy of the records are there. I'll reserve the order. At what stage the case is pending?
Yes.
At what stage it is pending? Trial is pending. Trial is
Trial is
still pending. At what stage?
Now, my lord, statement of defense and argument. my lord.
Or last stage?
Yes. No, I checked, my lord, through NIC, my lord. I checked.
Delivered or it is supposed to be delivered?
No, my lord, on 13 matter is fixed for statement defense and argument. And my lord, section 9 says that at any stage, plea of juvenility can be raised.
On 13th, case is fixed.
Yes, well, on 13/8.
Then on 12th, I will deliver the judgment. Third, Mr. K. Rahman, learned counsel for the petitioner. Also on Mr. K. Das, learned additional public prosecutor, as well as Mr. L. Gogoi, learned counsel appearing for the respondent number 2. Let this case be listed for delivery of judgment on 12/8/2000. Judgment delivered.
No, that is co-accused, lord. It is co-accused. I have examined the record, man. That is co-accused, lord.
Who has been acquitted?
Co-accused is acquitted. No. We have annexed the judgment also in this petition.
List it on 12th of August for delivery of judgment.
Well, he is behind the bar.
No, on 12th it will be finalized. If I accept the version of the district judge, he may remain behind the bars till trial court, subject to what trial court feels. If a fresh inquiry is directed, then you may get benefit of bail. That I will consider. By Mhm. Yes, what is your prayer?
My prayer is for correction of the order dated.
Correction?
Yes, Lord.
What correction?
In the order dated para number 2, the case number was wrongly typed. That has to be corrected. The gist of the case, your lordship, this gist is of another case,
Oh my God.
not from this case. Then your lordship, in para number 8, 3 co-accused have been granted bail. It should have been 2 co-accused. Then your lordship in para number 12 next. This para is not related to this case.
I have not checked properly.
This para is not related to this case. Then in para number 24,
You have mentioned it in the,
in your lordship, my in para number 3 of the I've mentioned.
yes, you have anything to say? Okay. I'll allow the application. Check, you have mentioned the
Yes, sir.
changes which
Yes,
are required to be
Which are
made,
required, I mentioned.
because
I mentioned the omitted portions also, which paragraph has to be omitted.
because this might have happened due to copying and pasting from the order of the co-accused.
Yes. No, not co-accused, actually, lordship. There were 2 bail
Prolonged
petitions.
incarceration.
There were 2 bail petition of the same co-accused. So from the previous, from the same accused, from the previous bail application, it was.
I'll verify.
Yes.
This falls within the category of typographical.
Yes. Typographical, your lordship.
And rectify.
Para number 24 has to be also omitted, your lordship.
You have mentioned
Yes,
it.
I have mentioned everything.
Okay. I'll do the chamber. I'll pass orders in chamber.
Much okay.
Hearing. How much time it will take?
Time, my lord.
But today, then it may not be possible. What is the matter?
Matter is for quashing of the FIR, charge sheet as well as the proceeding, my lord, criminal proceeding. That is, the allegation was brought against the petitioner only on the basis of an electronic evidence, that is a viral video record clipping, my lord. So that is my only, my lord. I have, my lord,
We'll fix another date.
yes, my lord, written argument also there I have.
Who is appearing for the other side? State or Mr. R.M. Das is shown. Who is R.M. Das? Heard.
And social welfare department has got nothing to do with in this case, my lord. Here the informant is the, my lord, child protection officer, my lord. Respondent number 2.
He must be representing the child protection officer. Heard Miss S.B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Due to paucity of time, this matter could not be taken up for hearing today. List this matter when?
My lord, the short date, because petitioner number 2 is 85 years old and totally bedridden, my lord.
suggest
There is no interim protection also.
Suggest
Next week, next Thursday, my lord.
huh? 14th. Let this matter be listed on 14th of August. Finish.
Two matters, my lord, 15
Both. 14th of August.